छोटा सा
आपको दो मेरे पास नहीं
There's one more list of dates from respondent side. From respondent side.
Yeah, my lord, this is a case. My lord, give me, my lord, 5 minutes to explain the whole issue, and then I will answer, my lord, every query. My lord, there was an advertisement for appointment of assistant professor in the department of orthopedics, and there were other advertisements in the same advertisement. 21 departments were also advertised. Now the petitioners have, and the essential.
What is the date of advertisement?
So the Annexure 4 date of advertisement is 2018, 28/3/18, Annexure 4. My lord may have a look of the advertisement. That's very relevant. Advertisement Annexure 4 at page 26 of the writ application.
26.
Of the writ application. My lord will, page 26, Annexure 4.
Yes.
My lord, names of the department, left hand side. My lord, there are various departments, but we are concerned with item number 11, orthopedics. There are 4 vacancies. 1, my lord, scheduled caste, and 3 general. So far, orthopedic assistant professor is concerned. Now, after this, my lord may come to page
No, we are concerned with this category.
assistant professor.
No, sir.
Unreserved. Unreserved. Yeah, 3 posts. Now, my lord may come to
26. Okay, after 28. 28.
Lord 29, page 29. My lord, capital D,
28.
Huh?
28.
page
28.
29.
28. My lord, D,
Yes.
assistant professor. Essential for the medical candidates for general discipline, so and so. Experience for the general as the last date for submitting of the application. From 3 years teaching and research experience in recognized institution in the subject, especially obtaining qualifying of so and so. Essential medical condition for super specialty in this. Now, my lord will come to, this is the essential requirement. So far, my lord, the advertisement is concerned.
So this advertisement and rules of recruitment tallies each other.
Yes,
So for a specification of qualification.
Lord, yes, that.
So shows
Now, it is in terms of the Indian Medical Council.
all right.
Yes.
No, department has not issued rules of recruitment.
My lord, yes.
Where is that? The Indira Gandhi Institute of Medical Science rules.
Lord, the rules of recruitment is not there. What is there is,
All right.
Lord, you also will please to see IGMS regulation 1984.
It is a rules only.
Rule of Rule 6.
Regulations. Where is that regulation?
Lord, that regulation is here. I give respect. Lord, regulation for the purpose only I am showing that 2 things. The government has adopted that the AIMS rule will be applied. Number 1. Number 2, there will be permanent selection committee in terms of the rules.
No, we are dealing with Indira Gandhi Institute of Medical Science.
Yes, yes.
not government.
Create a rule for that, and in that rule, there is a 5 establishment committee, one of the Asthai Chayan Samiti, permanent selection committee. The job of permanent selection is to select the candidates, their merit, interest, etc.
Correct, sir. Where is the source, sir? Where is the number of posts identified in the Indira Gandhi Institute of Medical Science?
Lord, then that is the post. Lord, you also will find the different posts have been notified in the advertisement itself.
Not advertisement. Where is the notification, establishment of post in the Indira Gandhi Institute of Medical Science?
Lord, that I am not aware.
If it is not there, you don't have, you mean the Indira Gandhi Institute have no business to notify the vacancies.
No, what they have been notified.
Who is representing Indira Gandhi Institute?
They have never.
Who is representing? Council.
My lord,
Who is representing Indira Gandhi?
my lord,
We'll ask them, sir.
may I request, Lord, something further I would like to show, and then my lord.
Sir, we will go to the root of the matter. Foundation, we have to establish foundation that the posts are available.
90 appointments have been made out of this advertisement.
Huh?
90 appointments.
Sir, thousands of posts are advertised and filled up. We are not worried about that.
Only what I am saying is, and same procedure was followed.
Rules of recruitment is required to be examined. Whether the institute has rules of recruitment governing the post or not.
तो एम्स का ही फॉलो करते हैं ये लोग.
Huh?
Rules of the एम्स they follow.
Show us, sir, where is the adoption of AIMS rules is adopted?
Lord, that is annexure.
Annexure F,
Annexure F,
page 20.
page 23, which says that they have adopted the rules of AIMS.
Where is that? Annexure F means?
Annexure F,
Lord, this is the only thing is the pages are not telling it.
Then we will admit this matter.
As you know.
Leisurely we will hear.
खाली पेजिनेशन करा दिया जाता ना. पेजिनेशन नहीं है ब्रीफ का. That is the whole difference.
We are asking few documents.
I have given in the list of dates. See, Lord.
Sir, we'll ask the institute. They are the author.
It's a government order.
Sir, sure, sir. If it is a government order.
91 वाला है सर. बड़ी स्पेशल स्टैचू क्या होगा बच्चे.
No, this is internal communication. Where is the government? Asked by the.
Just a communication to the director of IAM.
No, this is not. This is only internal communication. We want a notification or resolution passed by the Indira Gandhi Institute of Medical Science.
Lord, as per your lordship direction, Lord, when a doctor is appearing on behalf of IGMS, the last order your lordship had directed.
Yes, correct. What assistance he is giving you?
Lord, he is saying that it has been adopted by Board of Governors.
Correct. Where is that document?
That document has not come here.
Then what is this? What is the purpose of asking the official to be drafted?
Give me 1 week, Lord, I will bring it.
No, what is the purpose of summoning him?
That he,
Him means we have last time we have directed one of the official who is well conversant with the matter shall be drafted. Who is the vice chancellor of this?
by chancellor is not here, Lord.
Then
Director is here.
ask your director to be present.
My Lord, I will bring it tomorrow, day after tomorrow, my Lord. I will bring it on day after tomorrow, fix it on either on.
Lord, I will request give me few minutes. What is this Indira Gandhi Institute?
Sir, do you have a document? Establishment of the Indira Gandhi.
Lord, the very statute creating this under a special statute of 1984 and 84 that
You have document?
Lord, that act I have brought up. Yeah.
Please pass on the act.
Yes,
Lord, I am supplying act. I have also.
And Lord, this
Act is
act,
there.
and this act was amended, Lord, in 2008. Amending act. There is a Hindi, English version, your lordship will find in the bottom also below. And this is the amending act of
The relevant regulation number
that is,
for
it is
permission to notify regulation.
regulation below, that is your lordship will find that power to frame rules below is the,
Sir, item number 12, page number 20.
my lord.
Take. Staff of the institute.
It is
Got it, staff of the institute.
a body corporate, my lord.
Whatever it be, staff of the institute.
Yeah.
But the assistant professor is also part of the staff of the institute.
My lord.
Where is the staff, assistant professor?
Nothing is there. Unfortunately, my lord, that is good. The rule they have framed, that is in Hindi, my lord, there is no English translation of
I
that.
am Lord supplying 2 copies of rules also.
In this case, my lord, what your lordship will find, they have constituted several committees, and at page, my lord, third page of this rule, your lordship will find Hindi Chayan Samiti, Asthai Chayan Samiti.
Item in respect
Is
of
it
assistant
rules or
professor.
regulations? Niyamavali?
Rule, my lord.
Where is the post of assistant professor?
No post is notified.
Then where do we get the assistant professor for the first
Really
time?
not what happened in 2008. This institute was converted as a medical college. Amending act I have brought you.
Medical, it was converted into medical college.
Medical college, my lord.
On what date?
That is, lord. The amending act is of
2007.
2008. Same that. This is lord.
13th
It came into force now from 13th of February 2008. Amending act. I tried to find out, lord.
The medical college rules is consisting of assistant professor.
No, nothing. No rules have been framed till date.
Then where did they get the post?
Well, Lord, that is the, and one of the things your lordship will see, in this case, the Chayan Samiti, the selection committee delegated its power to a person.
No, first of all, we must know where is the post. Hey, court master, what is? Put a tag.
Lord, I have been informed that the state government has sanctioned it, and I will bring it on record.
Document to show that the post of assistant professor is established in your institute.
That's true. Lord, just give me to next week. I will bring it to record post also.
Take down. There is no assistance from the principal, sir. Indira Gandhi Institute of Medical Sciences, despite a person who has been drafted, so and so. Give his name. Therefore, registry, director, and other concerned person who is well conversant with all the relevant rules and regulations must be present with documents. He must prepare three or four sets of all regulations in a chronological order in order to understand how the institute has developed on its own with reference to various amendments from time to time. Release this matter next week. ये वापस दे दो.
I will further.
Serial number 2, the state of Bihar others versus Satish Chandra Jha for the Eden Street. Sri Raj Sinha.
I appear for the appellant Milord in this case, and I am filing hard copies of the rejoinder to the counter affidavit filed by the Respondent, my lord.
Dr. Santosh Kumar.
Kindly be taken up on the record. Krishna sir. Online, it has already been filed, my lord, a report.
All right, are you ready?
Lordship.
Entered by way of supplementary.
Writ application. Yeah, respondent joined as what?
As travelers here in this port, my lord, on block level under NREP scheme as accounts clerk.
Accounts clerk.
Lordship.
On
That-
what date?
That is, my lord, white annexure 234.
What is the date?
Date is, my lord, 15/12/2089.
Huh?
15/12/89, my lord.
No, what, he was appointed as 27/5/81 as what?
My lord, he has been appointed under NREP scheme.
NREP.
Yes.
Ah.
And following that policy by the government, he has
No, he was initially appointed as under NREP scheme as a what?
on the post of joint junior accounts clerk and provide annexure 5 of the writ petition may kindly be seen, my lord.
1 second. On 30th November 1989, he was appointed as what?
He was appointed, my lord, as गणीय लेखा लिपिक के पद पर की गई.
What is meant by that?
जूनियर अकाउंट्स क्लर्क.
Junior accounts clerk only.
By the order of DM, my lord, Darbhanga.
No, was he directly appointed through some selection process or what?
No, he was appointed directly under policy decision of the state government.
Where is that policy decision of the state government?
My lord, I have stated that in supplementary affidavit as well as.
No, mere statement is not sufficient. Where is the state of the policy?
My lord, may kindly come to annexure 2,
Annexure 1 to
annexure 1, my lord, of the writ petition. That is dated 1/12/1985. A letter written by the Rural Works Department to the Accountant General, my lord, on Patna. Rashtriya, may I place that?
No, whether this policy
Lordship.
provides for counting of service rendered in
No, no,
NREP?
no,
No.
no. There is simply a policy designed to absorb them.
No, correct. Absorption.
Absorb them on, by way of adjustment. They were surplus staff. He was working on ad hoc basis under BHRTC. The word, my lord, by way of adjustment, it has been samayojan. Now the direct word absorption in English, my lord, this is samayojan, adjustment. The situation arose as a result of
Twofold order. Well, first order is that and further that water signal prestige person plus transmission stop
You counselor plus something.
Adjustment, sir.
First जो file हुआ
Earlier. Where do we go?
Is there anything about continuation of the service or previous service being taken into account at later stage?
I have brought on record by way of filing supplementary affidavit, my lord, the queries were raised by this honorable court in February 2020, and by that, my lord, I have laid down, stated there that my facts may be, my lord, I may be permitted to present those facts.
No, yes, whether state government or corporation, have they taken a decision? What is required to be done with reference to the service rendered for about 8 years? How it has to be dealt with, whether it should be counted for purpose of.
No, it will not be counted as
Is
per.
there any policy decision or not?
My lord, Annexure 4 may kindly be seen, my lord. I may be permitted to place that of the writ petition.
No, we have a copy of the writ petition.
Yes, my lord.
Annexure A4 is also there.
4 and 5 may kindly be seen, my lord. What is the conditions have been laid down in Annexure 5, my lord.
Sir, it is only a half a page, not even half a page.
My lord, Annexure 5, as page 26 may kindly be seen. That is dated 30th of November 1989. And here in para 1, my lord, यह नियुक्ति समायोजन औपबंधिक रूप से ग्रामीण विकास विभाग द्वारा.
Annexure 5 is something else. It's the order of Block Development Officer Hayaghat.
Yes, my lord. By that, the direction policy decision as per that direction was issued to the district magistrate Darbhanga to bring them to send their name and address for the purposes of appointment in the NREP under NREP scheme at block level.
Sir, adjustment and all right. What happened to the previous service? 8 years.
That has got. This is what I am presenting by Annexure 5, my lord. That
No, have you denied or what?
we have denied. We have
Denied in writing.
denied in this letter itself.
No, who is this person to decide whether the past service is required to be counted or not? He is not the person. Government is the competent authority.
Government by way of
We are talking
Lord,
about
Annexure 2.
Annexure 3.
My lord, Annexure.
That is order.
Yes, my lord. My petition is kindly peruse Annexure 2, 3, 4, and 5. I may be permitted to present Annexure 2, my lord. That is at page 22. Direction for appointment dated 9/12/87. This is the letter issued by the government secretary to the government.
This appointment,
Yes.
sir, repeatedly we are asking you how to treat the intervening period from 81 to 89. Whether in writing any of the officer have rejected their claim.
Lord, this is what the document says that
Document does not, in nowhere document say that between 81 to 89, the petitioner or junior accounts clerk who have been adjusted are not entitled to any service benefits rendered between 81 to 89. It does not say at all. Now the state government has to take first decision, that's all. We will modify the single judge order. Yes, take down. Sir, there is no policy decision. We will remand the matter to the state government to take a decision.
They are permitted to.
Show us any document that the 81 to 89, the service is required to be counted for the purpose of retirement benefits. Show us the document.
my lord, I have brought on record by way of filing rejoinder, my lord.
Sir, but you are filing, but where is the document? We are asking
Under the rules.
repeatedly. We are asking.
Yes, Lord, under the rules of SCP scheme as well as the pensionary rules, my lord. We have stated in rejoinder petition, my lord, the rule 58, 59 and 60 of the pension rules.
Correct, sir, but there is no determination by the authority. What would happen to that service? Either you have not taken a decision, either rejecting or accepting.
Said that he was working on ad hoc basis as a surplus staff after.
We know that.
Yes.
There is no policy decision. Yes, where is the document?
With my lordship permission, lordship, what I want to submit, lordship.
Is there any document of the state government?
Lordship, what I want to say, submit before lordship is the issue involved in this case is no more res integra. I have filed the counter affidavit in annexus C1 may kindly be seen, lordship.
No, you are not able to appreciate this code. We are asking repeatedly, is there any policy decision of the government or any authority to count the past service for the purpose of retirement benefits or not?
There was a policy decision, lordship.
Show us this, show us, sir. We are repeatedly asking you. Show us.
It has been mentioned in the order itself, lordship.
Show us, sir, document. We want a document or a policy decision of the state government. Otherwise, you have no right. Please take a short question for consideration in the present. This is whether respondent is entitled to count his service from 27/6/1981 till 30th November 1989 towards retirement and other service benefits or not. So, initially, respondent was appointed under a scheme called NREP. Thereafter, he was adjusted with the which corporation?
He was working under BSRTC and adjusted under NREP scheme at block level, Darbhanga.
Rural Department of Government.
Rural Works Department.
Rural Works
Department.
Grameen Karya Vibhag.
From 30th November 1989 onwards. In this backdrop, the learned single judge has not appreciated with reference to any policy decision of the state government that such of those persons who are working as a junior accounts clerk in the then NREP and whose services have been taken in the Rural Works Department. Even to this day, none of the parties have apprised this court relating to policy decision of the state government relating to counting of service rendered in the NREP scheme could be counted for the purpose of retirement benefits and other service benefits. In this regard, the state government is hereby competent authority is hereby directed to take a decision as to how to count the service from 27/5/81 to 30th November 1989. If there is any policy decision in that regard, a order shall be passed and communicated to the respondent as to whether he is entitled or not. If no scheme is existing as on today, the concerned respondents are hereby directed to evolve a scheme. Take a policy decision in respect of service condition for the aforesaid intervening period and the nature of appointment initially and thereafter adjusting him in the Rural Works Department. Such a decision shall be taken up by the concerned respondent / government within a period of 3 months from the date of receipt of this order and communicate the decision to the respondent. To the above extent, the order of the learned single judge is modified.
Obliged. Obliged.
Serial number 3, Magadha University Bodh versus Dr. Manoj Kumar Jha for the period 3 at the department.
Number 120 days.
My lord, would you please to see the June order, my lord? That is page number 24, my lord. Page number 24, my lord.
What is the delay? Where is the number of days of delay?
Lordship, last occasion, Lordship has directed to submit that how it is not identical to the batch cases LPA, which were.
Plus, the number of delays hasn't been mentioned in the IF.
Will reject on that ground itself.
My lord, liberty may be given within. Liberty may be given to file fresh, my lord. Within a short span. My lord, within a week would be filing, my lord. Within a week, your lord, we would be filing.
Within a day you do it, but subject to payment of cost.
Some lenient views.
Please take down time and again. Repeatedly we are taking note of interlocutory application filed by the state or state authorities while filing the IA for continuation of delay in respect of filing of a LPA. Number of days of delay has not been indicated. Statutory rules provides for filing of LPA within 30 days. Therefore, interlocutory application for condonation of delay must disclose the dates and events and the number of days of delay. Accordingly, IA 1 of 2019 stands rejected, reserving liberty to file fresh interlocutory application with a period of 1 week. From subject to payment of cost of rupees 2,000, cost shall be remitted in the High Court Legal Service Authority.
Lordship, connecting MJC, Lordship, they have taken order there that this MJC will be put up after disposal of LPA. So, Lordship, the MJC is pending due to.
All right, within 2 weeks it will be decided. They are going to file a rectified IA for condonation of delay.
Serial number 4, the state of Bihar versus Bihar State Board and Building and Construction Employees Union for the payments in Karya's order.
91 days delay, my lord, in filing the appeal on the IA number 1 is there.
Have you mentioned the days?
Yes, my lord. By pen it is mentioned.
Which paragraph?
First paragraph, my lord. Page number 2. IA number 1, my lord, starting from.
Paragraph 4.
1, my lord. Paragraph 1 on page number 2, my lord. At running page 43, my lord.
With regard to limitation, my lordship, I have no objection, but.
All right, we will first IA number so condonation of delay application in filing LPA. Followed for the reasons stated in the application and affidavit, 91 days. Yes. Yes, on merits.
And on merit, my lordship, I pray for the case may be placed day after tomorrow because original counsel Mr. P.L. Pathak is in my lordship. I have also mentioned, but due to objection, my lordship.
My lord, the writ petition was allowed, granting parity with one Vineet Kumar judgment, my lord. My lord, in earlier case, this common judgment was also assailed in LPA number 766 of 2019, in which my lord has formulated the question. May I pass that question, my lord? That has been formulated.
What happened to that file?
That has gone to DB2, my lord. That is listed before DB2, my lord. Honorable DB2, my lord.
Then why the similar? We will pass on this to DB2.
My lord, that may be that is subject to my lord's consideration, my lord. The only prayer is, my lord, that the contempt is also listed before honorable single judge, my lord. Say in the meantime, the judgment may be stayed, my lord.
When counsel for the respondent appellant submitted that identical matters are listed before the DB2 examination. Hence, the registry is hereby directed to list this matter before DB.
number
LPA number 766 of 2000. May I read the first
Number
2019. May I pray for stay because and the contempt is already listed before the.
go and request before the DB2.
Oblige.
Serial number 5, the state of Bihar versus Gaurav.
Take off that continuation of delay. Let the same thing be decided by.
May I appeal, Your Lordships? There is a delay of 110 days in filing present memo of appeal.
110
days, Your Lordships.
Who is
Para one.
respondent?
The state of Bihar, Your Lordships. State and its authority.
Have you mentioned the number of days?
Yes, Your Lordship. In para 1 itself, Your Lordships. The IA application which was filed on 13th of January 2023.
Who is on the other side?
I am representing the writ petitioner
You
respondent.
have no objection to allow IA.
But we have not been served for a copy of the interlocutory application, the IA.
You are representing whom?
Yeah, I am representing my lord respondent number 123.
The writ petitioners.
Counsel for the appellant is hereby directed to serve a copy of the unserved copies of the papers before the next date of hearing. And is this matter next week?
All right.
The hearing for orders from office notes, serial number 6, Union of Indian Others versus yes, Lakara for the appearance
Which are the respondents?
Lord.
You have to take fresh steps
Yes, Your Lordship.
for service of notice.
Yes.
Is taken.
And if Your Lordship.
The appellant is hereby directed to take fresh steps for service of notice to such of those unserved respondents
My Lord,
in 2 weeks.
Yes, Your Lordship. If Your Lordship permits, then if the notice, the copy of the notice may be served upon the respondents through the department because he is working as head constable in the CISF unit at Durgapur.
The appellant is permitted to take steps for service of notice to the unserved respondent to the head of the department of the concerned respondent.
And in 4 weeks.
4 weeks.
serial number 7, Jay Prakash University.
Your Lordship, may I have a leave? Your Lordship, may I have a leave just to mention, my lord? If the in serial number 3, my lord had been pleased to grant 1 week time. It may be extended to 2 weeks, my lord. Reason being that, your Lordship, in this way, only 2 days or 3 days are.
Already to give the 3.
Yes.
My lords, I have removed all the defects, my lords, except one page I could not, my lords, since that is not available with me, my lords. In the records, my lords will find page 242.
Whatever it may be.
My lords, it can be.
And moreover,
my lords,
lordship,
the Supreme Court,
based on which the Supreme
Court has already decided the matter, my lords. It can be disposed of in terms of that.
Yes. That is his SLP was dismissed by Honorable Supreme Court, Your Lordship. On that score also, LP has to fail. LP has to fail.
Both the counsels, the learned counsel for the appellant submit office objection has not been removed.
That may be ignored, my lord.
The normal court.
Lordship, may I pass on the order of Honorable Supreme Court?
LPA would have been dismissed in the light of a earlier order. At this stage, earlier order dated so and so. At this stage, for the respective parties on instruction submitted that identical matter was subject matter of SLP number so and so, and it was decided against the appellant. In this paragraph, both the learned counsel for the respective parties on submitted that the present LPA be decided in terms of the SLP number so and so. Accordingly, present LPA stands disposed of in the light of SLP number.
We have provided the order, my lords.
Pending IA, if any, stands disposed.
Serial number 8 is adjourned for 1 week. Serial number 9, the Union of India versus Mukesh Kumar for the business, Dr. Vipin Kumar Dev.
In the light of order dated 15 December, my lord, I have filed supplementary before your lordship.
Huh?
I have filed supplementary regarding the original application filed by the respondent, my lord.
In this case, my lord, 15/12/22 order has been passed, my lord. This case was differentiated, my lord. These respondents have come, my lord, in 2015, my lord.
The kindly see paragraph 3 of the supplementary of the. The original application filed by the respondent out of limitation period, my lord.
Where are the OAs of Mukesh Kumar, Jitendra Kumar and Abhay Kumar?
Yes, my lord.
They have now admitted, my lord, that the persons have come in 2015.
Where is that?
My lord, they have given one supplementary, my lord, in which, my lord, they have.
No, in the supplementary filed by whom?
By the petitioners.
Petitioner, I have filed supplementary.
You have filed. In that you have admitted.
Yes, my lord.
15.
Then the matter is covered by the other bench, other matter.
Yes, my lord.
Included with the counter.
The original
There is no case insofar as Mukesh Kumar, Jitendra Kumar, Abhay Kumar.
Yes, my lord.
Huh?
Respondent 1, 2 and 4, my lord.
Correct, sir. Mukesh Kumar,
Yeah.
Jitendra Kumar and Abhay Kumar Sinha.
Abhay Kumar within time.
15 में है कि नहीं? Sir, they have come in 15 or not?
Sir, I am repeating.
15, my lord.
3 persons, sir. 3 persons. Mukesh Kumar, Jitendra Kumar, Abhay Kumar.
Yes, my lord.
The lordship's order has been included with the R1 with the counter affidavit.
Give the LP, the writ petition rejected insofar as other cases.
The R1 at page 16 with my counter.
What is the writ petition number?
Writ petition number 4895 of 20.
4895
of 2020. Decided on 4th July 2022. We are returning dismissal. That is an extra R1 with the counter affidavit.
Yes. Take down the present petition. Present petition insofar as respondent number 1 Mukesh Kumar, Jitendra Kumar and Abhay Kumar Sinha. In bracket respondent number 1, 2 and 4 are concerned. Matter was deferred on 15/12/2022 in order to ascertain whether their original application filed before the CAT was within the time limit or not. Today, Land Council for the respective parties submitted that their original application was within the time limit of 1 year, and their applications, their original application was maintainable in the absence of any delay, and section 21 of the Administrative Tribunal Act is not attracted so as to file a application for continuation of delay. These material information has not been disputed in the supplementary affidavit filed by the petitioner. In the light of these facts and circumstances, writ petition filed against Mukesh Kumar, Jitendra Kumar and Abhay Kumar, respondent number 1, 2 and 4 respectively, are concerned. Writ petition filed by the respondent filed by the Department Union of India is hereby rejected in the light of order passed in CWJC 4895 of 2020 decided on 4/7/2022.
Next is also similar.
Same order. But you have to give the respondent number and date, respondent number.
Respondent number मिला 1, 2 and 3.
Give the names also.
Barred by limitation below of the limitation period. Name is मिला निरंजन भारती, राजेश कुमार रंजन, विष्णुदेव पासवान.
Respondent number.
Respondent number 1, 2 and 3.
1, 2 and 3.
I have stated para 3 of the supplementary duty below. In this case below, earlier on 70 November below, your lordship award cost to the respondent below.
Serial number?
Earlier 2 cases मिला cost was awarded मिला serial number 8 and 9 and 10. Now मिला the cost 9 and 10.
9 and 10 over. Now serial number 11, no?
11.
Number 11, Alok Kumar versus the Union of India for the business championship.
In this case मिला your lordship may have a look to the order dated 15/12/2022.
कॉपी दिया है कॉपी नहीं दिया है
Where is the document, sir? No.
Your Lordships, we filed supplementary affidavit. Your Lordships on 6/1/23.
6.
Same document has been repeated मिला. There is no other documents मिला.
So let him point out.
I'm sorry. I'm sorry.
His case.
I'm sorry.
This is second supplementary.
This is supplementary counter affidavit.
In the index, you say second supplementary. In the affidavit, you say supplementary.
Your Lordship, in the index it says second.
27 January 2023.
Okay.
Which is the relevant document?
Your Lordships will come straight away to Annexure R by 14.
Number?
Yes, page 38. Your Lordships, office clerk. Your Lordships, at page 39, 4/1. Apprentices, trainees who fail to complete the prescribed training courses satisfactorily may be given a repeat course. So far as exam का कहाँ है? Exam वाला.
No, we want examination.
Your Lordship, 3/1, Your Lordships, at page 38. 3/1, candidates should be warned at the time of their recruitment that their retention in service will be dependent on their successfully completing the training and passing the requisite test.
Where is the requisite test prescribed for the post?
Your Lordship, successfully completing the examination, Your Lordship, that was part of the...
No, first of all, where is the prescription of a particular examination to particular post?
Your Lordship's...
I'm sorry, Your Lordship, one of the documents they have not included in the affidavit.
But it is relating to prescription of examination to the post of senior section officer, or what is this post?
Your Lordship, the course that they have to go through, Your Lordship,
Senior section engineer,
Your Lordship,
electrical,
Your Lordship,
or a drawing.
Your Lordship,
The post,
kindly, we had asked you, kindly supply a copy of course module of training recruited through RRB. And Your Lordship, they have given the course, and the course, Your Lordships, itself speaks of test. At the end of the course, after the all the classes are complete, then serial 32 is the exam. Serial 32.
When did you conducted examination? From during the intervening period from the date of petitioner's appointment till today.
The date of the exam.
Date of examination, and asking him to appear for examination.
Lordships, they are giving the date the results were declared, but the date the examination was held.
26/3.
26/3.
Result.
Huh?
This is the result.
Dinako. The examination, Your Lordships, organized on 26/3/2018. And thereafter, Your Lordships, he had on 3 occasions, he had asked for a second chance. That was also given. In that also he didn't succeed. Then he gave a request.
Where is the foundation, prescription of examination for post?
That is in the course itself, Your Lordships. The course.
What is that course?
Course that is prescribed, Your Lordships.
No, course is for the post of senior section engineer.
Your Lordship, SAC electrical, that is course module for SAC electrical.
This is a document of 2023.
2023,
and that is also not on record.
There is a letter covering letter of he peeps over here.
The Honorable Court is asking
submission.
the very questions is very big.
This is a covering letter we had requested.
Alright, shows the inception of passing of certain examination or a test to the post of senior section engineer, electrical or drawing.
Many persons have appointed with me has not been sent any training. They are continuing in regular post. I have succeeded 46 weeks training. I can be terminated only if I declare unsuccessful in field training. I have succeeded in field training also.
Lordship, this is the course module that has been sent to us on 16/1/23, and
that is prospective.
16/1/23, the letter has come, Your Lordship.
Then what is the date of a prescription of examination? Whether candidates have been informed that you are required to pass the so and so test or examination? Where is the document?
They go through the course, Your Lordships. They go through the training course, and this is the entire, Your Lordships, the course module for the training course that they go through.
We are not able to understand with this document.
Then Your Lordships, Annexure 13, Your Lordships will see. Your Lordships, your query. Page 27, Your Lordships may see.
Page
27.
27 of what?
Of the supplementary affidavit. two italics, two.
This is for supervisors. Concerned with the senior section engineers.
Your Lordships, I am instructed that they also come under the supervisor of electrical program. The section is.
So as that any document supervisor and senior section engineers are common.
जो बोलिए उसका डॉक्यूमेंट दिखाइए, बिना डॉक्यूमेंट के कुछ मत बोलिए. And Your Lordships, this 52-week induction program with institutional training in 2 phases has been approved for all categories of directly recruited supervisors. The induction program includes 8 weeks of field training and 14 weeks of attachment or job experience. The details and sequence of training under induction program are given Annexure 1. That is what I have passed on to Your Lordships. And Your Lordships, Annexure 14, 3 itself says the qualifying examination at the end of the initial training of directly recruited non-gazetted staff through the Railway Service Commission. Now, that would include, Your Lordships, in my humble submission, all non-gazetted staff.
You can't speak which is not there. We want a specific senior section officer, senior engineer, section engineer.
Where is it in Group C? Group C that senior section engineer comes in Group C, show that to. Your Lordships may just put it after 1 or 2 days. I'll get a prize.
Who is the author of this 6/1/2023 covering letter?
Covering letter, Your Lordships, 361. Your Lordships, it is the senior personnel officer. Construction for CAO CECR MHX Patna.
Is he not misleading this code?
Rupesh Chandra.
Is he not misleading this code? Is he not misleading this code? Because the enclosures nowhere display SSC electrical. Who has authorized you to him to issue such letter?
Your Lordships, he had asked this information from the principal of the ZRT.
He is not a postman. He is not a postman. He is an officer of the railway department. He must apply his mind. He can't just act like a postman in forwarding papers. And that apart, misleading this code.
he had asked for the course module of training for SSC electrical.
But some other papers have been enclosed, which is not relevant to the SSC.
Senior. Your Lordships, they are showing me this rules for recruitment and training of Group C and Group D and working staff. In that, Your Lordships, in the same chapter, the senior section engineer is also mentioned, but I would pray Your Lordships may adjourn it for 2-3 days. I'll go through it myself before I make any submission.
So we really disturbed with a covering letter like this, and you have been misled.
And I'll go through it, Your Lordships. I just offhand, without seeing the content.
Just to overcome our previous order, some documents have been prepared and place it on record.
Let me, Your Lordships, permit me to go through it. I'll go through it, understand it, and if any more information is required, I'll get.
Who is the Chief Personnel Officer?
Chief Administrative.
Chief Administrative Officer. What are you doing? Can't you give the material information? Are you not custodian of these records? Are you custodian of these records or not? As a Chief Administrative Officer. Unnecessary wasting the court time. Order dated 15/12/2022 has not been complied. Therefore, personal affidavit of the Chief Administrative Officer within bracket construction Mahendra Ghat, Patna, is hereby directed to file along with the relevant document without confusing this court in producing a number of documents. The core issue involved in the present petition is whether senior section engineer / electrical / drawing was required to pass any prescribed departmental examination before completion of his probation. This court is repeatedly asking the concerned respondent. On the other hand, various materials have been placed on record by means of a supplementary affidavit, and none of the documents are relating to prescription of a relevant examination for the post of a senior section engineer / electrical / drawing. To release this matter after 2 weeks as a last chance. Failing which, matter would be decided on the score that respondent railway department have not prescribed any departmental examination for the purpose of completion of probation of a probationer who is holding the post of a senior section engineer / electrical / drawing. Release this matter after 2 weeks.
Even Milad, 4 persons have been selected with me, Milad. Their document may also be. They have not been sent for any training, Milad. They are permanent.
Why I
have already stated on oath, Milad. This is part of pleading. Oblige.
If their counter statement is silent, we'll accept your contention.
The heading for arbitration serial number 15, Manoj Kumar Das versus the State of Bihar for the appearance to Uma Kantiwari.
15.
I pray for only Also for few cases only.
Why?
Officer is here, but the DM is having some mechanical trouble. That's why he is. That's late, lordship. Chief education officer is here, lordship. But and DM Jahanabad is on way, lordship.
Why officer was summoned?
Virtually, lordship, I got little late, lordship, in furnishing the rules as was warranted by this honorable court on earlier occasion, lordship. That's why it was my fault, lordship. I am producing the rule, lordship. Honorable Singh has merely said that since there is a alternative remedy before the state appellate authority, ordering to
after few cases
lodged.
Senior number 16, Radha Pandey versus the State of Bihar for the teenage Sri Ambarnath Tiwari.
Problem.
Yes. What is Lord Sin? Where is the director? Have you prepared a combined senior list of class 4 employees?
No, lordship. I have lordship explained in the lordship reply, which has been reply lordship has been filed lordship on that.
Along with the reply statement, you have filed a combined senior list.
Lordship. Separate seniority list lordship has been. Separate seniority list lordship has been.
No, why combined senior list is not prepared?
Reason is lordship that the scale of treasurer guard and the other class 4 implied lordships are different. Therefore,
so what? They should be placed below. The person who is getting a higher pay, he should be placed over and above.
the problem is lordship that the even in class.
The problem is the combined the source power is this. 4 persons, 4 source cadres are required to be promoted to the post of class 3. Then where is combined senior list?
At the time of consideration of promotion, their date of initial engagement in class 4 lordship, that will be considered. But fact remains lordship, I have explained lordship, the lordship will prepare separately on the basis of a scale. For example, lordship in class 3, accounts class.
Sir, how are you going to operate a separate list for the purpose of promotion to the class 3? How are you operating seniority list of a class 4? 4 lists are there. How are you going to operate? If four vacancies are available, 4 vacancies.
Then lordship, date of appointment, initial date of appointment lordship will be considered after going through the all seniority list.
Now in respect of a person who is in the higher pay scale, how are you going to fix?
So that is on the so far the grant of promotion is concerned, that will not be considered that he is in a higher scale.
Therefore, why you did not prepare combined senior list? Combined senior list is required to be prepared.
Only one thing last man consider, because he was appointed in the as a work.
Sir, whatever, we are not concerned with that. We want a combined seniority list of feeder cadre. Where is that list?
Combined seniority list is not there.
Without that, you can't operate.
But fact remains, one thing that I am clarifying.
No, I will not permit senior to argue in the mid of the argument. When you have comments, you have to argue.
He has prepared lawsuit. Senior counsel lawsuit, he is appearing.
Then you should have asked for after few cases. Why did you commence the argument? Once you commence the argument, you have to complete. We will not permit the senior to appear in this matter.
So far, lawsuit case of the appellants are concerned.
Combined senior list.
Lordship, they are initially engaged in the work as established in.
We want only combined seniority list.
That combined seniority list, Lordship, has not been prepared.
When are you going to prepare?
Kindly, Lordship, grant me, Lordship, certain reasonable.
May I come in the meeting if possible?
No, sir. We will not. We will not entertain this type of.
That is there. Like my lord is saying, that combined seniority list is not there.
When the class 3 post is required to be filled up by A, B, C, D, you have to prepare combined seniority list. You can't prepare a single list.
But so far, Lordship, this organization is concerned, Lordship, since 82. No promotion in any cadre, because reason have I assigned, Lordship, in this. No, in any cadre, no promotion, because in 1995, Lordship, meeting of the entire command area development agency.
Where is the class 3 seniority list?
Class seniority list I have not annexed, Lordship.
Why? We want to see class 3 post, assuming that 100 posts are there, 100 posts were filled up. Who are all retired, who are all promoted next? How to know whether vacancy has occurred or not?
But in this case, Lordship, since 1995, entire post, Lordship, has been kept in dormant position, because at the level of departmental minister, meeting of all command area development agencies are held. In that meeting, Lordship, all the command area, Lordship, head of the command area, Lordship, stated there is no work for the workforce, Lordship. Therefore,
no work for whom?
Persons who are already been in service. Therefore, no promotion, nothing is there, and all the.
All right, sir. Where is the order to show that class 3 post? For example, I am working. I have retired. Thereafter, the post is abolished. Vacancy is abolished because I don't have work.
Decision.
Where is that decision?
Yes, that decision is that the post.
Sir, post is abolished. Where is the decision?
Abolition, no, that dormant condition. सुसप्ता अवस्था में जो लिखा हुआ.
Suppose 50% are working, top 10 have retired. They don't want to fill up because the 10%, 50% don't have work. Then where is the question of promotion? In that event, from the date of his retirement, the post is deemed to be dormant. Where is that?
That decision, Lordship, at the level of Honorable Minister.
Where is the decision? Minister.
I have an next, Lordship.
Minister decision is not an order.
Yes, kindly see, Lordship, page. I have page relevant portion is the page.
Sir, minister order is in the form of government. Article 166.
That decision, Lordship, later on communicated to all, Lordship, command.
Meeting का part है ये
page
का part है ये बोलिए. Meeting. It was resolved in the same meeting, chaired by minister.
They say that individual senior with reference to
जो कंपैशनेट अपॉइंटमेंट का रिलैक्सेशन होगा वो बढ़ा दीजिए.
the reason point
Hard copy is there, Lordship. There I have.
Where is the order or notification issued under Article 166 of the Constitution after minister decision? Minister decision is not final. It should be in the form of notification or order.
In 2000.
I may be permitted to file.
We will not give. We will not accept.
E-filing हुआ है.
Filing हो चुका है.
E-filing has already been done.
What document in that you want to rely? 166 notification is there?
That notification is not.
Simply you can't dump papers here. This is not a corporation, Patna corporation. Yes, your director, no assistance. You are standing like a rock.
There was a letter from Under Secretary Government of Bihar. These 95 and 97 decisions will be relaxed only to the extent that appointment on compassionate ground can be done. In the 230 Under Secretary, that annexure is
page 46.
Under Secretary is government.
by the order.
The order of the
order or letter?
Letter.
On the order of the government.
At the order of the government, word is Nideshanusar. That letter lawsuit has been communicated to all command areas.
Give that. Sir, is it order or not?
बोल रहे हैं.
Which is there?
Page 46. Lord.
Page 46. Is there any government? Petition form of executive order.
Annexure H.
Lordship, page 46.
It's a communication to all concerned.
Lordship.
For keeping the post dormant with regard to orders dated 95-97. Where are those orders?
That decision, Lordship, I have Lordship annexed the decision taken during the course of Lordship at the level of
देशानुसार पढ़ी जनता सरकार का होगा.
then per 95.
बता दीजिए तब ना सरकार का होगा.
This letter is Lordship at the instance of government Lordship. Word is Nideshanusaar. उपयुक्त विषय के संबंध में कहना.
Where is that Nidesh?
That is Lordship. I have annexed Lordship that decision Lordship. Annexure. Relevant portion is Lordship at page 47 decision.
Not portion. Where is the order? Do you understand executive order?
Lordship.
Minister thinks he himself is a government. He will take a decision. It should be in the form of executive order. In most of the cases we have come across, ministers take a decision and it will be kept in file and it will be acted on his decision. In the absence of an executive order under 166, Governor of State Governor has delegated the powers to the Under Secretary for issuance of order. Where is the order?
95 Lordships I have placed on record Lordship the decision of the Lordship of the Honorable Minister Lordships.
Sir, again you are repeating the same thing?
Sorry, sir.
You want us to repeat the same thing? On the other day, we have come across pharmacy post. Decision is in the file. It is not in the form of executive order. And further advertisement, selection, recruitment from 83 to this day. We hold that there is no decision because executive order is not passed. You give effect to the promotion, that's all.
My Lord, kindly, I have also brought on record that proceedings of the meeting Lordship in which decisions were taken that posts shall be kept.
Please,
I'm Lordship.
You are assisting, you are a law officer of this court. You have to assist fairly submit whether is there executive order or not.
That order Lordship I have not.
If it is not have, then you want to produce the same thing?
Sir, in the year 2008 only this was acknowledged by government, sir. We have, as far as we have found the papers, sir.
No, if there are no orders, they are entitled to promotion. That's all. If only decision is taken and kept under the table, it is not an order.
Then this decision was again reiterated in 1997 also, and then Lordship 2008.
So was their order, sir.
Initially, loss with this command area, loss within the control of agriculture.
We are not concerned with that, sir. We want only an order.
At that time, agriculture department loss with the head department. So there, the decision loss must be. One opportunity lawsuits I will.
How many times, sir? See the order sheet. It is more than petition copy.
That time lawsuit was granted. Sought by appellant. I have not lost.
You have not taken time.
Lawsuits.
Huh? You want to read order sheet from time to time.
For my understanding concern lawsuit, I have never taken time.
क्यों सामने में ऑर्डर शीट है
हमने हम
कुछ बोला जा रहा है
always appellant's lawsuits.
At your request, it is urgent on 12/12/2022. Then counsel for the respondent is hereby directed to produce relevant documents, relevant rules of recruitment, governing the post of clerk, executive order, resolution, seniority list of feeder cadre. Who is Anjani Kumar? Satish Chandra Jha. You have appeared. Your name has been recorded. And you say you are not taken time? Today, counter affidavit has been filed. Within bracket hard copy. The same is taken on record. Perusal of the same. It is evident that the concerned respondent have not prepared combined seniority list of the feeder cadre to the post of a class 3 post. On the other hand, they have prepared individual cadre seniority list. They have not apprised this court with reference to how each seniority list is being operated for the purpose of filling up of the post of class 3 by promotion method. At this stage, it is submitted that one of the source cadre is carrying higher pay scale than the other 3 sources. If it is so, general principle is that such of those persons who are in the higher pay scale, they should be placed over and above the lower pay scale for the purpose of treating them as seniors. In this regard, combined seniority list has not been combined seniority list was mandatory. Further, it is submitted that from 1995, from the year 1995,
he was granted time on promotion. He was 89.
You are not concerned with that, sir. You are not operating promotion from 95.
Since 82 itself.
From the year 1982, the post of class 3 is not being filled up for want of work. For want of work.
One thing,
if it is so, such of those persons who are holding the class 3 post as and when they further promote or retired, the post stood abolished. To that effect, it is learned that concerned ministry has taken a decision and it is kept in the file. However, consequential executive order under Article 166 of the Constitution has not been notified with reference to delegation of power of His Excellency Governor of the state, within bracket, full stop. If the executive order has not been issued under Article 166 with reference to the decision of the ministry, concerned ministry, the year 82, 1995, 1998, and other dates, if any, in that event, whatever the decision taken by the concerned ministry has no value. In other words, the decision of the ministry is not a government order. Full stop. Courts have time and again held that the decision of the concerned authority or a minister or a note file has no character of an executive order. Full stop. In the present case, matter is relating to filling up of certain post of class 3. Full stop. The class 3 posts were notified under Article 309 of the Constitution or issued under executive order within bracket, issued under Article 166 of the Constitution, like executive order. The concerned authority is hereby directed to produce executive order insofar as abolition of a post along with the person in the class 3 category from the year 1982 to this day shall be placed on record, failing which we have to draw inference that there is no completion of a decision in the subject matter of abolition of the post of class 3 for the reasons that there are no executive order after a decision is taken at the ministry level. Therefore, the concerned respondents are hereby directed to produce executive orders issued under Article 166 of the Constitution or amendment of any rules issued under Article 309 or any act / bylaw / regulations. If the aforementioned documentary material is not placed on record before the next date of hearing, we would be proceeding with the whatever the material available on record. List this matter after 2 weeks.
May I point, Lordship, post was not abolished. Post was, Lordship, kept in dormant condition. So
whatever you want.
Then my Lord has, Lordship, not abolished. Class 3 post was not abolished, Lordship.
And then what is the word used, abolition, other than abolition?
Dormant.
Dormant. Instead of abolition, you use the word dormant.
And one
within bracket, abolition.
That's one thing. One person, Lordship, was granted promotion junior 1984. 1982, Lordship, 5 persons were granted promotion. One person who was left, who was, Lordship, senior. Then he was granted in 1984, Lordship. He was also
in the despite the decision in the year 1982, you have promoted one person.
No, he was left, Lordship, because he was senior to that 4 person, Lordship. Therefore, Lordship, I have.
So you have implemented the decision 82. Not extending promotion.
Promotion, Lordship.
Correct, sir. You are not given promotion.
Given, Lordship, given.
All right, we will agree.
Lordship,
where is the executive order? Show us. That's all.
Maximum time, Lordship.
2 weeks, sir.
My Lord, because.
No.
Because Lordship, the department is.
Then we'll impose the exemplary cost and adjourn the matter, because in the previous order we have made it clear which are the documents are required to be produced. We have not produced.
That my lord is querying that document. I have not other document Lordship I have produced. Other document Lordship I have produced.
All right. Shall we pass order, further order?
I will also produce this.
Go and get.
Serial number 17 is added for next week. Serial number 18, Mari Krishna Pratap Singh versus the state of Bihar for the periods. For the periods with Bihar and Jharkhand.
It's a 2007 matter. The matter relates to Milord's Anganwadi Sevika. The panel is of 2007 Milord, and the challenges of the appointment made to the respondent number 4 Milords. My lord will kindly see the impugned order, Milord.
Fourth respondent? No, fourth respondent name is not reflected in the single judge order?
Milords, subsequently I was added. Now this appeal.
The LPA you have added?
Yes. No, Milords. In the writ application only Milord she was added, and thereafter Milord's appeal has been filed.
No, IA was allowed.
Milords allowed. Everything has.
Why it is not reflected in the order?
Milord, the appointment were made in 2007 by the board. They did not file, this petitioner was ousted. He was not declared fit. Yes, let me speak.
My appeal, Milords, let me summarize the entire issue, Milords of the matter.
You have a chance.
No, I wanted to only say.
No, sir, you will have a chance.
Milords
here has been engaged by their client.
Milords, I'll just cut short the entire issue, Milord. I'll go into the details what is there, Milord. Milords, the writ application, I was made party, Milords, pursuant to the direction of this honorable court, Milord. Milords, for the appointment of Anganwadi Sevika, Milords, a panel was prepared. The panel consisted of actually 4 persons, Milord, but one redundant, 3 persons came into the picture.
1 second. To rectify this. How LPA is internal.
Review petition.
How is it? Application, you find out how to should allow him. Find out another office has committed error. They don't put things. It should have been done on me. That is the reason date is required. Carry forward, no? I don't know.
ऑर्डर निकालिए सर, ऑर्डर निकालिए ना। एलपीए और फाइनलाइज में स्टेटस को मिला हुआ है। कहाँ मार्क करिए तो स्टेटस को जो मिला दोनों एलपीए ये वो इश्यू ना लीजिए।
Reflecting the name of
ऑर्डर कॉपी इसमें एलपीए में मार्क करिए और मार्क करके यहाँ पे रखिए। Party is definitely the Supreme Court. You are not a party. Are you doing advocate or history?
party includes also it is itself.
रखिए ना।
Do it that. When you added the party and the order was passed not reflecting the name of respondent number 4 order sheet, didn't you point out this fact to the court?
Respondent number 4. Lord, if my lord will just permit me 2 minutes, my lord. This because since
No, we are not on merit. We are on.
I am not talking.
Because the amendment has not been carried over while issuing the order sheet, order of the judgment.
But
Your name is not reflected.
But my friend is here.
So what? Everybody is here.
No, lords. इनको notice गया? Notice गया है and thereafter.
Sorry, madam, everything is correct, but in the order your name is not reflected.
Who's?
How LPA is maintainable? Take page.
I am the appellant in the appeal, my lord.
Correct. How your LPA is maintainable against the order passed on 14/3/2018 when your name is not reflected as a respondent.
Lords, I was the respondent in the writ jurisdiction.
Correct. But it has not been carried. That is what.
Since no, my lords, everybody's name is there because respondent number 4 is.
Show us from the order passed by the single judge in CWJC.
And yes, I am showing that, my lord. Respondent number 4 is Kumari Sangeeta, for whom my friend is appearing. Now, my lord will kindly see the impugned order. That is the last paragraph.
No, from the cause title of the impugned order, you show that your name is reflected.
Yes, yes, my lord. My lord.
The court master, give this.
Acha, my name is appearing in the order sheet. Yes, respondent number 4, Durganand Jha. Yes, respondent number 4, Durganand Jha. जी, हम मार्क करते हैं क्या इसमें? डॉट करते हैं. This is what?
Yes. Cause title.
Cause title.
Name of this Kumari Pooja Prabha Singh is not.
Where is the Kumari Pooja Prabha Sinha?
I am showing that in the order sheet, last paragraph, it has been mentioned.
Last paragraph, we are cause title.
Lords, I am probably, Lords, the name of the petitioner is appearing, my lords, for the respondent number 4. The lawyer for the respondent number 4 is appearing as Durganand Jha.
Body of the order is there.
And in the
cause title refers to the parties. Show us from this. Where is the party name?
Acha.
What is this?
Oh, very. Because this is not my mistake, my lord.
Huh?
This is not my mistake.
Without knowing that your name is there or not, you have filed LPA.
No, but it is in the body part also, and the notices were issued. Now I will tell, my lord, why it is lacking, my lord. In fact, my lords, respondent number 4 had come before this honorable court under the writ jurisdiction.
They are not on merits, madam.
I'm not talking about the merit, my lords. Why my name is not there, I'm just pointing it out. My friend came before this court, my lord, challenging only her appointment. She did not make me party, my lords. Before she could have made me...
We are asking you, unless this order is...
How can I...
This order is rectified, how LPA is maintainable?
लॉर्ड साहब नहीं ठीक है अब हुजूर ये तो हुजूर दिस इज नॉट द मिस्टेक ऑफ आस मिलॉर्ड इट इज ओनली दैट सिंस वी वर मेंशन्ड इन द बॉडी पार्ट आल्सो एंड माय नेम वाज आल्सो रिफ्लेक्टिंग एंड देयरफॉर मिलॉर्ड्स वी फाइल द एलपीए ये कह रहे हैं कि यहाँ पे दिस इज द डिफिकल्टी ऑन द पार्ट ऑफ रिस्पोंडेंट नंबर 4 हु शुड हैव एडेड मी एज अ पार्टी at that point of time. Writ application, I was...
Yes, we are not at all finding any fault with that. We are finding fault with that in the cause title, your name is not there.
Correct.
Then you should, before filing LPA, you should have requested the single judge to incorporate your name in terms of the amendment of the cause title.
Since it was already there in the body part, my lords.
So we should ignore.
So...
We should ignore.
We chose to... Now, my lord, since this matter, I can just humbly request.
Yes, present LPA. Sorry, the present LPA is by Kumari Pooja Prabha Sinha, wife of Jitendra Kumar. In CWJC 7713 of 2010, petitioner Kumari Sangeeta did not arraign Kumari Pooja Prabha Sinha as a necessary and proper party, even though she was selected and appointed to the post of Anganwadi Sevika. During the pendency of the CWJC 7713 of 2010, the petitioner Kumari Sangeeta has arraigned Kumari Pooja Prabha Sinha as a fourth respondent. This is evident from the CWJC number 7713 of 2010 papers. In other words, Kumari Pooja Prabha Sinha has been added as a fourth respondent within bracket newly. After disposal of CWJC 7713 of 2010, the registry must have committed error in not incorporating Kumari Pooja Prabha Sinha as a fourth respondent in the cause title. Therefore, registry is hereby directed to rectify the cause title in CWJC 7713 of 2010, decided on 14/3/2018. And place it on the present LPA in order to hear LPA matter on the next date of hearing. This matter after 2 weeks.
And they have filed the case.
I don't know what is it. Ask them.
What is the name of appellant? Is it Pooja Prabhas?
Yes.
Pooja Prabha Sinha.
It is, my lord, Pooja Prabha, my lord.
Pooja Prabha Sinha.
Pooja Prabha Sinha.
No, in LPA you have stated
Kumari Pooja Prabha Sinha.
Singh.
Sinha, my lord. Kumari Pooja Prabha Sinha. Kumari Pooja Prabha Sinha, my lord.
Our office note says that Singh, Kumari Pooja Prabha Singh.
It is even in your LPA.
That is affidavit or what? In your LPA cost title also you have indicated Singh.
No, my lords, I am reading through LPA. This is Kumari Puja Prabha Sinha, my lord, appellant. My lord will kindly see the first page. Kumari Puja Prabha Sinha.
Show it to her.
Yes,
Singh.
हुजूर मेरे पास
Same has been carried out by our office.
लिखा हुआ है. I don't know. It has been mentioned as Sinha in my copy, my lord.
In the meanwhile, the appellant is hereby directed to clarify as to whether appellant name is Kumari Puja Prabha Singh or Sinha, for the reasons that in the LPA documents both the names are reflected at various.
Name is Puja Prabha.
We will rectify, my lords, whatever is the mistake.
We are going to
Obliged, my lord.
appoint commissioner.
A vigilance, my lord, inquiry is required. Obliged.
Serial number 19, in this one, Mancho person to the state of Bihar for the appearance to Ikman and Bihar.
Yes, my lord, I am in contact with my lord, present to last order, my lords.
Officer should have raised the office objection in stating that verify what is the
Contact.
counter. The counter accept. Yes, sir. What is the matter about?
May I please, sir? Now, originally the petitioner was terminated, appellant was terminated, against which writ petition was filed. Writ petition was disposed of with direction to file representation and they will consider it. They appointed me. Now, this second writ application, against part of which I am before your lordship, that was for non-payment of salary for certain period. Presently, I am only against last part of the order at page 7, that there is no pleading in entire writ petition to the effect that during period 22-1995.
Para 8.
Paragraph 8 of the judgment, last part.
Read para 8 complete.
Yes, my lord. Having considered the facts and circumstances of the present case, I have the opinion that petitioner is neither entitled to continue in service for purported break in service in between period 20-1995 to 28-2012, nor is entitled to back wages for the said period. Firstly, on the ground that neither order cancelling appointment of the petitioner dated 20-95 has ever been annulled by any court of law, or there is any order which has been issued by the respondents directing for reinstatement of the petitioner herein, whereas, on contrary, the petitioner has been ordered to be appointed afresh on the post of peon by an order dated 21-8-12, which has also not been challenged ever by the petitioner therein, leading to one and only conclusion that the petitioner was satisfied with his fresh appointment rather than being reinstated in the service. There is no pleading in the entire writ petition to the effect that during said period 22-95 to 28-2012, the petitioner was not gainfully employed elsewhere. However, in the start of the justice and keeping in mind the fundamental service of the jurisprudence as also the principles of the equities, I deem fit and appropriate to direct that the period of service rendered by the petitioner is very inception to his career, that is from 24/11/87 to 12/9/95, shall be counted for the purpose of grant of pensionary benefit for the petitioner herein. Now, in reply to the counter affidavit in the writ petition, paragraph 7, I have said that I was never employed. Not gainfully employed.
Even otherwise, you are not entitled. What were you doing? Cause of action accrued in 1990.
No, I came earlier, my lord. I was working. Now, my lord, first of all,
Sir, between 95 to 2012 is the issue, correct?
yes,
20th February 1995.
to 28 to 30.
What happened on 20th February 1995?
In this period, my lord, I was before this honorable court contesting the matter. My earlier cancellation of appointment. I came to this honorable court.
Where is that order?
Yes, my lord. Annexure 6, page 25 of the writ petition.
Application.
After giving the facts, finding is page 28 of that writ petition.
No, this
paragraph 6.
97 writ petition is relating to what?
Yes, my lord. Against termination.
What is the date of termination?
Yes, my lord.
20th February 1995.
Yes.
This order has been set aside.
Yes.
Because
not set aside by this honorable court.
As long as it is not set aside, you are not entitled.
No, for the reason that the matter was remanded back to file representation.
Huh?
To file representation.
No.
I filed representation.
At least even to this day, whether this termination order has been set aside.
No, already. Either you say or let me say before the honorable court. My lord is asking question to me. I should be fair that whatever my lord asked,
yes,
that I should be.
Correct. Now we question whether this 20th February 1995 order has been set aside by any of the judicial forum or not.
Yes. Your lordship may have a glance to page 28, finding of writ 115, paragraph 6.
No, it shows that it has been set aside.
Yes, my lord.
Huh?
Yes, my lord. In other sense, it has been set aside because it will not be taken into consideration. That is said, my lord. In case letter number 21187 is found to have been issued by Engineer-in-Chief, Road Construction Department directing respondent of the petitioner as road labor, appropriate order be passed in accordance with law as early as possible. In any case, within 3 months from the date of receipt, production of the copy of the order before Under Secretary, Road Construction Department. As inquiry is to be met, compliance in my order about genuineness of contents of the letter number so and so 31187, it is meet and proper to observe that statement made in letter.
This is only observation to hold inquiry, but the order has not been set aside.
The order has been not to take effect. Now, my lord, the order by which I was reinstated, that your lordship will get.
What is the reinstatement order?
Yes, my lord. That is, my lord.
It's a fresh appointment.
No, just I give your lordship, my lord. My submission will be, it is not fresh appointment. Annexure 8, page 32. That is in terms of the writ petition.
Correct, sir. Whether it's a fresh appointment or a cancellation of 20th February 1990.
That is not said that it is fresh appointment. In view of the order passed with this honorable court.
So the word reinstated.
Yes, my lord.
Annexure 8. Reinstated.
योगदान के समय योगदान के समय सैनिक तक मुख्य
और fresh
he is appointed on a temporary post of order clerk.
Appointment is temporary?
Yes. On temporary basis.
Appointment?
Yes.
The word used is appointment.
What is it appointment?
Not a reinstatement.
No, what is used is appointment in terms of the order passed by this honorable court. And this honorable court has said in CWC 115 that that will not take effect. And so this order has been passed. Now, the honorable court says that only because I have not stated the fact
that I was not employed gainfully for that period. That will not be given to me. For that, my lord, I have said in the reply to the counter affidavit that I was not gainfully employed. And when I was re-employed, my lord, that is their rule. The state government guideline, and 13, page 37. Read of the writ petition.
Appointed in terms of order and so this order will be subject to any future order by type.
Order does not say a reinstatement, it is a fresh order.
Order, but this, my lord is right.
And there is no, order 95 order has not been set aside.
But that was said by Honorable Court that it will not take effect in CWC 115.
Correct, till a decision is taken. Now decision is taken only to appoint you, that's all. They are not stated, you have been reinstated. Reinstated means continuation. Appointment means fresh.
But my lord, Honorable Court says that all other benefit I will get. All other benefit I will get. That has been said by Honorable Single Judge.
No, better withdraw this LPA, otherwise our order will be affecting your further service benefits from 1995.
Already, your lordship may have a glance to the order, which is under challenge. This was not granted only because I have not said, whereas I have said. And in the interest of justice and keeping in mind. I'm sorry, my lord.
What was the post? Peon.
Class 4. Very poor person.
Has he retired?
Yes, now he retired. Oh, I'm sorry. Service. Oh.
Out of that 87 to 95.
95 to 2004.
That time, some years. Benefit of this only. 24/11/1987.
No, that is from the date of his initial appointment.
Initially appointed.
He is entitled. What is the reason for termination?
Reason for termination that one officer recommended my termination on the ground that I was appointed on compassionate ground, and that was for limited period, so I should be terminated. Others said that no, he was not on compassionate.
But otherwise, you are appointed on compassionate ground or what?
Regular.
Then where is the advertisement?
I have not an advertisement for appointment. It was not advertisement because at the.
Then what is the basis to say that I have been directly recruited as appointed?
Yes, my lord. At initial instance, I was appointed on daily basis. Thereafter, I was regularized.
Shows the regularization.
Yes, I will show.
Your services are regularized in the year 1987?
1987.
87. Shows the document that your services are regularized in the year 1987.
Yes, brother.
There is a difference of opinion among the officials. Appointed as
On
the
election.
ultimate.
In para 8 of my contract affidavit, my lord. In para 8 of my contract affidavit, my lord, my specific case was that letter never been issued from the department about regulation of the petitioner. For that reason, his services has been terminated, my lord.
Then now you have reinstated on what basis?
Reinstated our court directed to the
Correct, sir. In 2012, what is the reason to reinstate? They have asked only to hold an inquiry. This court has not directed you to appoint him or observe him or regularize his service. Only to hold inquiry. Inquiry is in his favor. Therefore, one has to draw inference that his services were regularized in the year 2012.
The learned single judge, my lord, just not interfere because the fresh order has never been challenged by the petitioner about the appointment of the petitioner on fresh, my lord.
No, the word used in the reinstatement order. No, you have used the misnomer word.
What is
Instead of reinstatement, you might have used the word appointment.
किसी से पदस्थापित किया जाता है. What is the my lord?
No, why did you appoint him on fresh appointment? What is the outcome of the inquiry? When the inquiry is in his favor, is he not entitled to all consequential benefits?
अस्थायी रूप से टेम्पोररी अनुसेवक पद पर नियुक्त किया जाता है. अंतरिक्त अनुसेवक पद पर योगदान की तिथि से पदस्थापित किया जाता है. That order में. That order never been challenged by the...
Sir, why he was reinstated or appointed fresh, assuming that fresh appointment? What is the reason? Huh?
Reason is not been established.
Reason is not there means?
Moreover, the service period has been counted for the purpose of the pensionary benefit also. That period has been counted.
Correct. Why he should be out of service, sir? If there is a dispute among your officials, whether he has been appointed on compassionate ground or regular basis or daily wager and regularize his service, don't they verify the records? Now ultimately you are granting benefit to him in the year 2012. Why he is not entitled to from 1995?
Because my lord, the department says, my lord, that letter never been issued from the department, my lord, with respect.
What action you have taken against such person? In whose office he has his services were engaged in the year 1987? Are you disputing that since between 87 to 95 he has not worked?
My lord.
He has not worked? Are you disputing?
Since 87 to 95.
Sir, 87 to 95, has he worked or not?
He worked, my lord.
Then what action you have taken against such of those officers under whom he is working? He was working? All Golmaal.
Complained by that letter was not sent to that it was not possible to verify its genuineness on the basis of
% back pay. 2% back pay is we'll grant a 50% wages because he has not worked, and during the intervening period he has not approached this court also to set aside the order 95 order.
LPA allowed in part.
And they will consider for pension as a full.
No, the single judge order is there, no?
Pension का तो दिया हुआ है.
Single judge order is there.
Wanted for the purpose of pension members.
50% back wages from 95 to 2012 for 12 years.
Number 20, Manju Sahai versus the Union of India for the Prisoner Sri Banda Prasad Deshmukh.
This case is covered, my lord. The only point in that they
Somebody in your favor or a state?
in my favor, we are presenting officer was not appointed in that. That my learned friend take instruction, although I pleaded in the writ application where there is no denial also.
Covered.
The
order of paper.
Order, sir. Just I could not bring the main in your lordship. I just
All right, we will take up in the afternoon. You go through this file. Give it to him.
this case.
Respondent Union of India Council has appeared without file. Therefore, we have provided him our file in order to produce the same and make his submission in the afternoon.
So this may 215.
2:15.
This order, it will go against me. Your lord.
Yes, it has. Without file, you can't appear.
Main file has not been brought to your lordship.
Whether main or subsidiary, supplementary, we are not concerned with that.
Lordship.
Be serious. You are representing central government. Without file, you can't appear.
Order dated 4/8/2022 has already been complied, your lordship.
Good.
Serial number 21, Ashok Kumar versus the State of Bihar for the Sri Arvind Kumar.
My lords, with your permission, this is my latest patent against the order of the Honorable Single Judge. I was seeking promotion to the post of staff officer in Bihar Police Services. My lords, the post felt vacant on 1st of December 2013. 1st of October 2013. 1/10/2013.
Where is the method of recruitment to the post of staff officer?
My lords, the method, I'm sorry, my lords, we've not.
Without the foundation, we can't decide the matter.
There are 9 sanctioned posts to the staff officer.
We are not concerned with that. We want to examine, we have to record. Method of recruitment to the post of staff officer is this, and the source cadre is this, and where is the final seniority list of source cadre, and show your name, up to what serial number they have given promotion to staff officer, and how your name has not been considered. These things are required to be examined. In the absence of records, we can't decide.
My lord may just hear me out. My lords, I will produce the.
Then why you want to argue?
My lords, because.
And counsel for the appellant is hereby directed to produce a method of recruitment to the post of staff officer, source cadre, seniority list, and up to which serial number the promotion has been given effect, whether his immediate junior in the source cadre has been promoted to the post of staff officer or not, and further whether appellant has questioned the validity of the promotion granted to his immediate junior or not. All these material is required to examine whether the appellant is entitled to promotion to the post of staff officer or not. If these materials are not placed on record before the next date of hearing, LPA would release this matter after 4 weeks.
Mullahs, this was not my case. I did not say that any junior was promoted. Now the rejection order, my lords, it states that since before the convening of the meeting of the DPC, I was promoted to the Indian Police Services. So therefore my lien in the State Police Service is over, and therefore I am not entitled to that promotion.
What is the date of convening the DPC meeting?
My lords, DPC meeting was to be convened on 26/11/2013.
26/11/2013. Were you in the state cadre as on that date?
No, my lords.
Then what is the locus standi?
I will, if my lords permit me, this is exactly where I was coming with.
All right.
My lords, in 2013, in the year 2013, at February 2013, my lords, there were 4 vacancies for this particular post, staff officer, and 1 probable vacancy for 2013, my lords, for which a DPC was held in February of 2013. 1 post, my lords, was falling vacant on 1st 10/2013, which was not taken into consideration at the time of holding the earlier DPCs, my lords. When you're calculating the year-wise vacancies, my lords, the 13 vacancy had to be included in that. I was 6th. So 5 posts were filled with people who were before me. 6th, they did not hold it. And immediately after, they...
what is the reason for not including the 6th vacancy?
My lords, that is silent, my lords.
That is silent?
They don't say anything on that. They are silent, my lords. The Honorable Single Judge...
What is the material to show that 6 vacancies were available as on the date of February 2013?
My lords, the counter affidavit of the state itself, my lords, they have stated that in 2013, they held 4 or 5 posts.
Where they have stated that 6 vacancies are available in the month of February 2013.
My lords, in that same paragraph, my lords, not in the month of February 2013, but there's a notification, my lords, and DPCs are held in advance. that is what it is said.
All right, on what date 6th vacancy was available?
On 1st 10/2013. My lords, the counter affidavit of the state.
So from the counter affidavit.
My lords.
Give the file. Writ application.
In the writ file, my lords. My lords, para 8 onwards, my lords.
Shows pinpoint where they have stated 6 vacancies are available when only 5 vacancies have been considered.
My lords, page 7, the 4th line, my lords. Internal page 7 of the counter affidavit.
Is it supplementary counter affidavit or what?
No, the counter affidavit, my lords, not the supplementary.
The pleading.
In the pleadings, my lords?
Page? In the, page 4 is the last pleading. Respondent number 5.
Page number 7, my lords, of the counter affidavit, my lords.
Which respondent?
Respondent number 1, 2, 3, my lords.
They have stated only 5 vacancies.
Now, my lords,
4 actual vacancies, 1 probable vacancy.
So 5 vacancies in February of 2013.
Yes.
Now the 6th vacancy is occurring on 1st 10/2013, my lord.
No, 6th vacancy arose on what date?
1st 10/2013. 1/10/2013.
Where is that? 1/10/2013, the vacancy of a 6th vacancy accrued?
My lord.
My lordship already has passed the order of single judge in paragraph 12, permitted to read out, my lordship.
Para 12 of what?
Order sheet, impugn order, my lordship, which challenge in the project LPM, my lordship.
My lords, in the same, at para 9 of this counter, para 9, which is internal page 8, they say that it is further submitted that after gap of nearly 1 month and 9 days of issuance of notification number 4933, dated 28/6/2013, Home Department, Police Branch, after calculation of vacancies and other essential formalities, initiated process for granting promotion to the post of staff officer on 7/8 and sent consent file to General Administrative Department for obtaining roster point on 10/8/2013. Now this is for this vacancy for which I was...
But as on the date of second DPC held in the 2013, you are not at all in the state cadre. You have already entered the central cadre.
Now, my lords, my twofold submission over here, my lords, and before the learned single judge, was that since your The calculation of the 2013, the first 1/10/2013 vacancy should have been done also in February 2013.
No, why?
Because, my lord, it has.
No, you show, that is the reason you show us. Before February 2013, the sixth vacancy was there.
My lords, when the initiation of DPCs is to be held, my lords, there are notifications to this effect.
Sir, show us the material that the sixth vacancy accrued in the month of February 2013.
It did not, so how can I say that, my lords?
Huh?
I cannot say that because...
Therefore, you are not entitled.
No, my lords.
Therefore, you are not entitled. Simple.
If my lords may just listen to me, my lords, what I am saying is that before the DPCs are hold, you have to find out how many vacancies are there. That exercise, my lords, has to be done 1 year in advance. These are the notifications. There are
notification that before 1 year they have to identify the vacancies.
My lords, Annexure 7.
What Annexure 7?
Annexure 7 of the writ petition, my lords.
What is that? Government order?
Yes, my lords.
Government order. Annexure?
Annexure 7.
Page?
Running page, my lord, must be 26. And not only this, my lord,
please don't jump to the conclusion.
Whether it says that within one quarter.
Page 26. First, second, third, fourth. The last line of page 7. अगले वर्ष में सेवानिवृत्ति इत्यादि से उत्पन्न होने वाली रिक्तियों की गणना वर्ष के पूर्व में किए जाने के संबंध में
There is such instruction within 1 year they have to prepare. Start 13. As of 5 vacancies of
all vacancy right.
no future vacancies required. No.
Or that is to be calculated वर्ष के पूर्व prior to the year. Prior to the year.
We are not satisfied.
My lords, government being the moral employer, my lords, and through catching out judgments as well, my lords, what transpires is before a vacancy is to...
When did you file a petition?
...2017, my lords.
Huh?
2017.
Cause of action in 2013. You have filed a petition in 2017.
My lords, my representation was rejected. And
what?
Thereafter...
Your representation is rejected on what date?
11/7/2017. 11/7/2017.
17.
20.
Where is the challenge to that?
The writ petition is the challenge to that, my lords.
No. In the prayer it is not there. Take page number 10, take page number 2. Where is the challenge?
My lord, what is this?
Where is the challenge 2017 order?
There's no per se, it is not mentioned.
All right, what is the date of entry into the central cadre?
My lords, 21/10/2013.
21/10/2013.
13.
Yes, take on. Present LPA is against the order of the learned single judge dated so and so. Grievance of the petitioner, grievance of the appellant in the writ petition is as under. Core issue involved in the present list is whether appellant is entitled to promotion to the cadre of staff officer in the pay band with a grade pay of rupees 8,700 in the Bihar Police Service cadre and promotion with effect from 21/10/2013. After you taking note of vacancy of the feeder cadre to the post of promotion cadre of a staff office. Next, in the month of February 2013, the respondent state have undertaken exercise of considering names of the feeder cadre to the post of staff officer for 5 vacancies. Undisputedly, appellant is entitled to claim his right promotion to the post of staff officer against the 6th vacancy and onwards. 6th vacancy was considered after 21/10/2013. In the meanwhile, appellant entered the central government cadre like IPS officer within bracket non-IPS. In this backdrop, the appellant had the cause of action in approaching this court in the year 2013 as and when DPC held for the post of staff officer in the month of February 2013. Whereas the present this litigation has commenced from the date of filing of a CWJC 15808 of 2017, stated to have been filed on 18/10/2017. Next part. Learned counsel for the appellant submitted that appellant grievance has been pending consideration with reference to representation and it was rejected in the year 2017. If it is rejected in the year 2017, then there is no challenge to the decision of the respondent state insofar as the rejection of appellant's claim in the year 2017. Next, Appeals Court in the case of P. Sadashiva Swami versus State of Tamil Nadu in para so and so, it is held as under. Next para. In the case of Vijay Kumar so and so, it is held as under. In the light of these facts and circumstances and the fact that appellant has approached this court highly belated approached this court belatedly after lapse of about 4 years to stop. Next, even on merit, the appellant has not made out a case in the light of observation made by the learned single judge
They are saying that the Panchayat Secretary,
Some of the
Lordship, they are
politicians' relatives' names are left out. Therefore, you have prepared second list.
Panchayat, since the custodian of record is the Panchayat Secretary, he will be proper person to apprise Lordship.
Then what kind of supervision made by these higher superior officers?
They are also having not the entire document. That's why they are helpless.
Then what is the object of summoning them? Just to visit the Patna city and they have come here for a picnic.
Only one diligence mechanic, and I will call him also, Lordship, with the entire record, Lordship. And if my friend may assist, Lordship, we come to the conclusion, Lordship.
Persons have changed. Both are same on this list also. First.
For issuing second.
Why destroyed? And they have not.
Who is the custodian of these records?
Panchayat Secretary, Lordship.
Then why you did not get the Panchayat Secretary?
I issued notice to all the concerned persons, Lordship.
No, when they have separated you these documents, can't you discuss with him and ask him to stay back?
As per the District Appellate Authority, Lordship, it is there. Manoj Kumar Das, पूर्व की मेधा सूची में नाम नहीं था.
Sir, if you keep on doing like this, it is impossible to decide the matters. I should make a serious observation. You are unfit to be a state council. Such a small tribal issue, we are unable to decide the matter for almost 1 decade. What kind of assistance is being given by the state? Don't you study the papers? Which are the documents is required?
As I stated, Lordship, Manoj Kumar Das can manage that was the observation of the District Appellate Authority, Lordship. After noticing all the parties concerned, Lordship,
We'll simply allow the appeal. There is no assistance, we will allow the appeal.
But my friend is presently having fresh cause of action due to non-joining of counterpart, Lordship, that is respondent number 7. That's why mail liberty may can be extended for.
No, why? Again 10 years?
As Lordship.
When are you bringing the appointment order in favor of the appellant? We want an order of appointment in favor of appellant. Because there is no assistance.
After emergence of 2009 rule, Lordship, we are going to appoint only those who are STET pass candidate, Lordship.
In respect of pending cases, you don't want to give?
As Lordship. As Lordship.
Policy has a retrospective effect.
Sending him to the State Appellate Authority when it was.
It is not proper to remand the matter to single judge. We want to decide because 2012 matter. And this matter relates to selection and appointment. You keep on tossing the file from one authority to another authority.
We are going to say how this, how a second person came into picture.
Who is the selecting and appointing authority to the post of Panchayat teacher?
It is at the relevant point of time, it was the Panchayat unit presided by the Mukhiya of the concerned Panchayat, Lordship. There was a team, Panchayat Secretary, Chairman is the...
means he is a politician.
Politician, Lordship. In the original enactment itself, there was a provision, Lordship. And for the block...
You are giving power to the politician in respect of appointment.
There was a team, Lordship. There was a team of some educationalist was also there, Lordship. And Panchayat Secretary is also there, Lordship. Under the signature of Panchayat Secretary, an empowerment letter has to be issued, Lordship.
What is the role of the collector in the process of any supervision and control over the Jilla Panchayat?
Sir, Zilla Panchayat sir has a separate sir, chief
Executive Officer.
Presently, the ADM of the district, sir, they are notified as the CEO. Earlier, it was the Deputy Development Commissioner. So more or less, sir, it is an autonomous body. So, but on specific issues.
No, Deputy Collector has no power over the Jilla Panchayat. You have to release the fund? No, they have their own independent fund.
Sir, the CEO is basically, sir, they do all the administration and superintendence over the works of Jilla Panchayat.
Now, somebody is holding the Chief Executive Officer post.
How this order will get this calculator countries or why?
Panchayat Secretary means they have are working in Jilla Panchayat or So what is the role of the Chief Executive of the Panchayat? He has no role.
Just a supervisor.
3 tiers are there, Lordship. Panchayat level, block level, and district level, Lordship.
Now, Gram Panchayat is headed by whom?
DDO, Lordship. Block Development Officer.
Block Development Officer.
Lordship. Director of Primary Education may can be
Collector to hold an inquiry.
Let's verify how it is second district.
Yes, taken pursuant to our previous order, Mr. So and so are present in the court. They are not in a position to assist this court as to how there were certain changes in the process of selection list, like changing the selected candidates' names. In the present case, there were 2 select lists. In the first select list, name of the appellant is not reflected. On the other hand, 7th respondent Subodh Kumar name is reflected. Similarly, certain changes were forthcoming from the second list. Matter is that the selection and appointment to the post of Panchayat teacher relates back to of the year 2012. The learned single judge has disposed of the CWJC while directing the appellant to invoke remedy before the appellate authority. Perusal of a certain statute, it is evident that as on the date of the impugned order before the learned single judge, there was no provision for filing a second appeal before the state, what authority?
State Appellate Authority.
State Appellate Authority. Therefore, learned single judge has committed error in asking the appellant to invoke remedy of a second appeal before the State Appellate Authority. Moreover, CWGC was pending consideration for the last 5 years, that is from the year 2012 to 2017. Therefore, it is not appropriate to ask the appellant to invoke a remedy of appeal. Since there is no assistance from the official respondents as to apprise whether the appellant is more merited candidate or seventh respondent. Further, Land Counsel for the appellant submitted that during pendency of the present litigation, the seventh respondent Subodh Kumar is stated to have been selected and appointed as a constable in the police department. Therefore, he is not interested. So also, he has not been represented by any counsel, or he himself has appeared in the present matter. In the light of these facts and circumstances, District Collector Mr. So and so, who is present in the court, is hereby directed to hold a detailed inquiry and proceed to pass a detailed speaking order. Before the aforementioned action is taken by the District Collector, he is hereby directed to give personal hearing to the appellant, and so also seventh respondent in the event of he appearing before the district magistrate. This regard, a report shall be placed on record before the next date of hearing this matter after 8 weeks. Personal appearance of the respondent stands dispensed until further orders. So, Collector, you collect all the material information, hold an inquiry, who is correct, who is not correct, give a finding, and also give finding if the seventh respondent is not interested, whether appellant could be accommodated or not, for the reasons that he is before the judicial forum since 2012, almost 1 decade.
Appearance of both your.
Next case adjourned for few cases in serial number 20, Manju Sahai versus the Union of India for the Discussion Tribunal.
In this case, Milad, confining to my submission, Milad, the sole issue, Milad, whether the proceeding is vitiated because of non-appointment of presenting officer, Milad, this issue has already set at rest by your Lordship, Milad.
What's the facts of the case?
Facts of the case. Facts of the case is, Milad. Petitioner is the widow of a railway employee, Milad, who died, Milad, on 12 January 2020. While he was in service, Milad, one charge sheet was issued on 20th March 2007.
20th
March 2007. He submitted reply, Milad, denying the allegation. Thereafter, inquiry officer's report came, Milad, on 1st February 2008. The inquiry officer itself admitted that the sole issue, the ticket in question on the basis charge was issued, was not produced before the inquiry, Milad. That was not available.
So charge was not proved?
It was proved.
Then,
although in the finding, Milad, he has stated that charges are proved. Thereafter, Milad, the penalty order was issued on 2nd February 2009.
How can it be 9? When the inquiring officer submitted his report on 1/2/2010?
1/2/2008, Milad.
8.
And I submitted reply, Milad, on 26 June 2008.
All right. The penalty was imposed?
Penalty was imposed on 2nd February 2009.
What is the penalty?
Penalty is, Milad, reduction of pay from rupees 4,600 in pay scale of rupees 4,600 to rupees 3,200 in pay scale of rupees 4,200 4,900 for 6 years with cumulative effect.
Repeat the reduction of pay 4,600 to 3,000.
Milad, 4,600 to 3,200.
4,600.
Pay was 4,600.
It was reduced to 3,200.
Milad. For 6 years with cumulative effects.
Appeal?
I submitted appeal. My husband submitted appeal on 22nd February 2009.
Rejected?
No, Milad.
It was not rejected.
It was not decided. In the meanwhile, after more than 5 years, a so-called notice was issued on 17/12/2013. 17/12/2013 for enhancement of punishment. I submitted my reply. Thereafter, the order was passed enhancing the punishment on 16/4/2014.
What is the punishment?
The punishment is Milad reduction to initial stage.
16/4/2014. No, show cause notice was issued on
17/12/2013. After more
the date of your reply?
21st January 2014. And order is Milad rejection. Order is Milad 16/4/2014.
What is the penalty?
Penalty is Milad reduction to initial stage of for next lower grade for 8 years with cumulative effect.
Reduction?
Reduction to initial stage of next lower grade for 8 years with cumulative effect. With cumulative effect. Thereafter, petitioner deceased employee went before the learned tribunal Milad, challenging the orders Milad. He has challenged the order Milad in disciplinary authority order Milad because appeal was not decided. Before decision of the appeal, he filed ON 2012 Milad. ON number 482 of 2012.
What happened?
In the meantime, during pendency of the case Milad, the deceased employee received the enhancement notice. He submitted reply. Thereafter Milad, it was in 14 Milad punishment was enhanced.
Now 16/4/2014 punishment order was challenged by means of amendment.
By amendment Milad.
Then OA 482 was decided on what?
Thereafter OA was decided Milad on 8/9/2016.
It was decided against you.
Milad.
What is the grounds?
The grounds Milad, the general grounds Milad, because it is a matter of disciplinary matter Milad, therefore it is not require any interference Milad.
Now in the present writ petition, what are the grounds?
Ground is Milad, the basic ground Milad. Now Milad, I have challenged Milad the very document which was relied on the basic charge memorandum of issued Milad. That was not made available with the inquiry officer. And
what is the document?
Document Milad. Just a Page 71 is the charge memorandum allegation. Document is Milad.
What is the document?
Ticket roll stationery number.
Ticket roll?
Stationery number.
Stationery number.
Number. N for Nagpur.
No, it's all right. It is the only document?
Only document.
That has not been placed on record before the inquiry. What do you say, Mr.?
Now the basic.
What is the other ground?
Other grounds, Milad. I submitted appeal Milad within time Milad. The appellate authority did not utilize his jurisdiction Milad. Now Milad, after more than 5 years Milad, he has issued enhancement notice Milad. There is a reasonable time Milad of 6 months Milad in the disciplinary appeal rules also Milad.
Which is the provision?
Rule. Just done.
Railway discipline.
Rule 25 of Railway Servant Discipline Appeal Rules 1968, Clause 5, within bracket it's small b.
Review.
Revision and revision.
No, title is review.
Rule 25 is revision. Revision and review, there are two. Now review has been inserted in Rule 25A. So the review power is only the president.
No, review, mentioning only review, not revision.
In the DA rules, Rule 25 at the top.
Everywhere it says the reviewing authority.
If you are pleased to see paragraph 25. 4. First is paragraph 25(4). No power of revision shall be exercised under this rule.
No, we don't have this 25, 1, 2, 3, 4. We have only one. The railway survey.
Railway survey.
And
1968.
1968.
ML Jan, that is the first book.
इधर रिव्यू है, ये बुक में रिव्यू है, ये रेलवे सर्वेंट्स के रूल्स 1968. In 93. What's this book? 135. ने रिव्यू कर दिया.
The 25 is
one more book is there. In this
it seems this part is not.
The notice which has been issued without revising as at case 34 under Rule 25.
Now, who has exercised the power of
General Manager, GM.
Is he above the appellate authority?
Miller.
Huh?
Miller. But the point for consideration is, Miller, there must be a time limit, Miller.
Huh?
There must be a time limit. My submission. 6 months, Miller. Now, Miller.
No, where is that you are using the 6 months, 6 months. Where is that?
Next page, para 5. Deep.
This book.
And I am passing my lord, two judgments my lord, of the Honorable Apex Court my lord.
Not able to understand
I am, sir.
provision of law.
I am, sir.
Not able to understand provision. Read this. Item number 5, sub rule 1. सब रूल किधर है? Rule 1.
The rule 2, so must be this one is rule 1.
No. It is sub rule 5. The item number 5.
Of sub rule 1.
Which is the item number 5?
Head of Department case Railway Service is control.
Anytime either on his own or motion, otherwise call for records. Time limit नहीं लिखा है. For the second item, it is then. No, after more than 6 months, from the date of the order. No action. An appellate authority other than the president.
Let us obtain the resolution action by the reviewing authority after 6 months.
Further provision is there, provided when this is undertaken by the railway. Appellate authority. Here about. You have taken this contention before the CAT?
Milan.
What is the outcome?
The learned tribunal has online where it is a matter of discipline, but we have no power to interfere in the matter. One more important point is very important. Your Lordship may consider. The punishment was imposed in 2014. The decision implies superannuated on 30th November 2017. 30th November 2017. And this punishment will be effective after his retirement also, because the punishment is up for 8 years.
No, 30th November 2017.
17 he retired.
But penalty was revised on 16/4/2014.
14 but for 8 years, period is for 8 years. Effective period for punishment is...
Alright, we will modify this. Instead of 8 years, we will say that up to 3 years.
Now, Milord, the very important issue your Lordship has decided. Para 6 of the writ application, I have clearly stated, Milord, the disciplinary authority did not utilize the power, adhere the power of Rule 9(7)(c), appointing a presenting officer. And in the counter affidavit, it has not been denied. In inquiry report also, no presenting officer appointed, Milord. Now this, your Lordship, Milord, a court judgment first.
Presenting officer was not there.
Lordship, presenting officer is not there, Lordship, but can you come to the...
No, sir, that is sufficient.
That is
mandates appointment of president.
one ground is there, Your Lordship. The point about presenting officer can be disposed of straightway. The provision regarding appointment of presenting officer is mentioned in Rule 99C of the Railway Servants Discipline Rule 1968, hereafter referred as rule, which is as follows.
Who has presented the case on behalf of the department against the
Inquiry officer, Your Lordship.
inquiring officer? The inquiry officer has played dual role.
Lordship.
Drama.
It is in the rules, Your Lordship.
What rule says that inquiring authority can present the file of the on behalf of the department?
If any, Your Lordship. This term is used as if any.
No, inquiry officer should be neutral.
Whether the disciplinary authority itself inquires into an article of charge or appoint a board of inquiry or any other inquiry authority for holding an inquiry into such a charge, it may, by an order of writing, appoint railway or any other. Para 9 of the judgment, Your Lordship. And then para 10 of the judgment.
Please apprise.
Lordship.
Without appointing a presenting officer, can you hold an inquiry?
Lordship, in
for the purpose of imposition of one of the major penalty. For minor penalty, it need not, because disciplinary authority can issue show cause notice and obtain explanation and proceed to pass orders.
In para 10, Your Lordship, it is also that presenting officer is optional. And up to the discretion of the disciplinary authority.
Whereas he exercises his power not to appoint presenting officer.
Rules, Your Lordship.
Correct. He has to follow rules. He has to say why he is not appointing presenting officer.
Lordship, in para 10 of the impugn judgment, Your Lordship.
We will not go by judgment. We want to go. We will go by only rules.
Your Lordship.
Correct, sir. Rule says that it is left to the discretionary of the disciplinary authority. Correct. If any, then he has to assign the reason. No, why I am not appointing presenting officer.
It is written, Your Lordship.
Has he recorded the reason why I am not appointing presenting officer?
It is the rules of the.
Correct, sir. Rule is giving two kinds of power. One to appoint presenting officer. One is not to appoint. By exercising not to appoint, have you assigned the reason?
May I read the one paragraph, Your Lordship?
Don't read from the judgment. From the record, you have to point out whether disciplinary authority has recorded why I am not appointing presenting officer.
It is made clear that the disciplinary authority to decide whether a presenting officer would be needed in a particular inquiry or not. If the presenting, that is rule, sub-rule 10, 12.
It is the discretion, Mr. Counsel, we are repeating. It is a discretionary power. Either to appoint or not to appoint. For not to appoint, why you are not recorded the reason? Rule 9C, which is the rule appointment of presenting officer?
9C, para 9 of the judgment, Your Lordship. Page 39.
You tell us the rule number.
Rule 9, bracket 9C, Railway Servant Disciplines and Appeal Rule 1968. That has been considered in the judgment which I have cited. The same rule, it was case of Railway Millard. In both the cases, Your Lordship has interpreted the same rule.
That is what I said. 9C. If the disciplinary authority he intends to hold inquiry on his own, question of presenting officer is not warranted. It is well-known principle.
Then the next paragraph, Your Lordship. Para 10.
Here the inquiring officer has been appointed or not?
Presenting inquiry.
Inquiring officer. Then you have to appoint invariably presenting officer. Shall we record that presenting officer is not appointed?
That is my averment, my lord.
No, your averment. He has to say no.
They have filed counter, it has not been denied. Inquiry, even it presumed from the inquiry report itself, my lord, PO has not been appointed.
What do you say, sir? Whether inquiring officer, presenting officer was appointed or not?
There was inquiry officer, Your Lordship.
My question is, what is your name, not your grandfather name?
Not obligatory. He accepts.
Please take down the instant writ petition. Petitioner, legal heir of the deceased employee.
Smriti Bihari Sahai.
Wife of late Krishna Murari.
Smriti Bihari. Smriti.
Huh?
Smriti.
No, sir. Who retired? Who is the workman?
Workman was Smriti Bihari Sahai.
The legal heir is Manju.
Manju Sahai.
Priti Bihari Sahai. So deceased railway employee was subjected to disciplinary proceedings. Particle charges were issued on 20th March 2007. It was concluded in imposition of penalty of reduction of pay is 4,006 from 4,600 to 3,200 for a period of 6 years. The cumulative effect on 2/2/2009. Deceased employee preferred appeal before the appellate authority, and it was not decided for about 5 years. General manager invoke rule 25 of the railway servants within bracket discipline and appeal bracket close. The rules come on 1968 for short rules 1968 and proceeded to issue a show cause notice on 17/12/2015 to the extent why the penalty imposed by the disciplinary authority dated 2/2/2009 shall not be enhanced. The deceased employee furnished his reply on 21/1/2014. Thereafter, General Manager enhanced the penalty to the extent of reducing the initial stage of next lower grade for a period of 8 years with the cumulative effect on 16/4/2014. Next paragraph. Feeling aggrieved and dissatisfied with the order dated 16/4/2014. Disciplinary authority order dated 2/2/2009, and in not deciding the the deceased employee's appeal, deceased employee filed OA 482 of 2012 before the Central Administrative Tribunal, Patna Bench, Patna, for short CAT. During pendency of the OA 482 of 2012, General Manager has taken steps to enhance the penalty. In the result, deceased employee questioned the validity of the enhancement of penalty dated 16/4/2014 in OA 482 of 2012. OA was dismissed, hence the present writ petition. Next, during pendency of the present petition, deceased employee Smriti Bihari Sahai died, and legal heir Manju Sahai is on record and pursuing the present writ petition. So next, learn counsel for the petitioner submitted that along with the charge memo, one document has been cited in support of the charge. Such a document was not marked in the inquiry so as to prove the alleged charge. It is further submitted that there is a total inaction on the part of the appellate authority and the general manager. Appellate authority has not decided the petitioners and the deceased employees' appeal. Even after lapse of 5 years from the date of imposition of penalty. On the other hand, when the appeal was pending consideration before the appellate authority, next higher authority dash general manager proceeded to issue show cause notice as to why penalty imposed by the disciplinary authority shall not be enhanced. He has imposed the penalty, enhanced penalty on 16/4/2014. Such exercising power after lapse of 5 years, it is not appropriate and it is not permissible in the light of provisions under Rule 25 of Rules 1968. It is also submitted that CAT has not appreciated the aforementioned contentions. In addition to the aforementioned grounds, Land Counsel for the petitioner has raised a legal issue that disciplinary authority has failed to appoint inquiring officer in terms of Rule 9C.
Presenting officer.
Presenting officer. He has also cited a decision of this court in the case of so and so. Per contra, Land Counsel for the respondent resisted the aforesaid contentions and submitted that the disciplinary authority has not committed any error. So also, next higher authority who has enhanced the penalty on 16/4/2014 and it was affirmed by the CAT. Disciplinary authority need not appoint a presenting officer. Therefore, the aforementioned contention of the petitioner is liable to be rejected. Heard the Land Counsels for their respective parties. Deceased Smriti Bihari Sahai was subjected to disciplinary proceedings on 20th March 2007 on certain allegations, alleged charge it was concluded in imposition of penalty of reduction of pay from 4,600 to 3,200 for a period of 6 years with the cumulative effect. Who's feeling aggrieved and dissatisfied with the order of the disciplinary authority, petitioner preferred appeal and it was pending consideration for more than 5 years and it was ultimately not decided in the light of the fact that next higher authority general manager took a suo motu decision to enhance the penalty while issuing the show cause notice First of enhanced penalty was ordered on 16/4/2014. First of next paragraph. Petitioner contended, counsel for the petitioner contended that document cited along with the charge memo was not part and parcel of the inquiry before the inquiring authority. The sole document which has been cited, it was not presented and marked as an exhibit in the inquiring before the inquiring authority. In the absence of production document proving the alleged charge would be contrary to law. In this regard, Apex Court in the case of Roop Negi so and so held that document cited is required to be marked in the inquiring before the inquiring authority. Apex Court in the case of UCO Bank versus Giriotra, it is held that if a document is cited, the author of the document is required to be examined. In the present case, document which has been cited has not been marked in the inquiring office before the it was not marked in the inquiry. Next, it is submitted that presenting officer was not presented the case on behalf of the department in the inquiring officer. When the disciplinary authority proceeded to appoint an inquiring officer, that event, it was bound and duty of the disciplinary authority to appoint a presenting officer to present the case on behalf of the department in a departmental inquiry. Inquiring officer and presenting officer need not be appointed in such of those cases where the disciplinary authority he himself proceed to hold inquiry. Such a situation is not forthcoming in the present case. Since inquiring officer has been appointed and who has held inquiry. In fact, inquiring officer has played dual role of inquiring officer and presenting officer, which is impermissible in law. Next one. General manager who has invoked Rule 25 of Rules 1968 is highly belated for the reasons that penalty was imposed on 2/2009, whereas the show cause notice for enhancement of penalty was issued on 17/12/2013. The two when the appeal was pending consideration before the appellate authority. At the best, general manager could have requested the disciplinary authority, appellate authority to decide the appeal. Deceased employees appeal instead of invoking the Rule 25. These issues have not been taken note of by the CAT while deciding the OA number 482 of 2012. Next up, in the light of these facts and circumstances, the petitioner has made out a prima facie case on the legal issue that the disciplinary authority has committed glaring error in not appointing presenting officer to present the case on behalf of the department, and further in not producing the cited document in the charge memo in order to establish the charge before the inquiring authority. Reasons have not been assigned by the general manager as to why enhanced penalty was required to be was warranted after lapse of 5 years from the date of disciplinary authority's order. In other words, there is a total non-application of mind. Further, it is to be noted that general manager has enhanced the penalty from a penalty to reduce initial stage of next lower grade for 8 years without cumulative effect, with the cumulative effect, without noticing that deceased employee was due for retirement on 30th November 2017. In other words, within 4 years, deceased employee was to retire. On the other hand, penalty was imposed for 8 years. Accordingly, petitioner has made out a prima facie case so as to interfere with the order of penalty dated so and so 2/2/2009, 16/4/2014, and order of the CAT dated so and so are set aside. Respondent is hereby directed to extend all service benefits which were due to the deceased employee and calculate monetary benefits from time to time from 2/2/2009 to till 30th November 2017, the date on which deceased employee had retired from service. Monetary benefits shall be disbursed within a period of 3 months from the date of receipt of this order. Failing which, writ petitioner is entitled to interest at the rate of 8% per annum on all arrears amount.
Obliged.
I think I want to say, Your Lordship. Earlier, Your Lordship has said that the Union of India has no brief, Your Lordship. That
what is wrong in it?
That may be expunged, Your Lordship.
No, what is wrong in it?
I do homework here, Your Lordship.
Huh? Don't be casual. You should be serious. You are representing central government.
By mistake, Your Lordship, the file was.
What mistake? Morning session order. Ask the concerned stenographer to delete.
Bill number 22, Managing Director of the Bihar State Food and Civil Supply Corporation Limited versus Anur is asking for the grievance to be shared.
May I draw your Lordship's kind attention to order number 3 dated 5/8/22.
Read.
Order number 3 dated 5/8/22.
Yes, sir.
Exactly, that is my submission. And one more submission, my lord. If your lordship would be kind enough to go through, my lord, the impugned judgment, this will demonstrate, my lord, that how, my lord, the Honorable Single Judge has been pleased to appreciate and, my lord, substitute the opinion of the disciplinary authority than by the court. This is another leg of submission, lord.
With respondent.
Up, sir.
No, Lord, I have received notice and appeared also. I will file counter.
Respond number 1. You want to file counter?
My Lord, respond number 1. Read petitioner, respond number 1.
All right. Learn counsel for the response. Number 1. It's time to file counter affidavit. Release this matter. 4 weeks? 4 weeks.
Serial number 24, Nirma Sinha, working in the state of Kerala, the senior institutional Kumar Sinha.
On the last occasion, Your Lordship has directed to place certain relevant informations, Your Lordship. We have filed supplementary counter affidavit, which is not on record, Your Lordship.
Not on record.
Not on record, Your Lordship. The
Where
same
did
is.
you file?
Yes, sir. Yesterday, Your Lordship.
Have you served a copy on the other side?
Yes, my Lord. Copy has been served. Copy has been served.
Registry is hereby directed to put up counter affidavit stated to have been filed on behalf of the state.
Reply yourself.
Huh?
I have replied the counter affidavit.
Yes, file a reply to that supplementary counter.
That reply was filed on what date?
My Lord.
What, my lord?
I have filed and that is only a part.
When did you file?
On 21, my Lord.
21. He said copy was served on yesterday.
Copy was filed in the registry, Your Lordship, yesterday, Your Lordship. But the copy has been served earlier.
Copy of the reply to the counter affidavit filed on behalf of the appellant. This matter next week.
Obliged, Your Lordship.
Serial number 25, 26, and 27 are adjourned. Serial number 28, Kanchan Kumari versus Union of India for petitioners, the Gautam.
May Lord. Sir, I come before your Lordship to set aside order dated 7/9/22, Lordship, passed by Honorable Patna at bench lordship, passed by Mr. Justice M.C. Verma, judicial member, and Mr. Sunil Kumar Sinha, administrative member lordship in OA.
What was the relief sought before the CAT?
Lordship.
Where is the original application?
That we have brought on
It
the.
is not enclosed.
We have brought on the record lordship. Running page 72, lordship.
72. Gracia, compensation.
My lord. Compensation only for that this petition I approached their lordship.
Why did you approach a CAT? CAT has no business. It is gracia, not compensation.
There is a scheme of the government starting from 99 lordship adopted.
Where is the scheme which provides ex gratia compensation in respect of snake bite? Snake bite.
My lord.
Where is the provision?
The husband of the petitioner died.
Where is the policy? The event of an employee suffered a snake bite and died. He is entitled to compensation.
It is not a specific.
Snake bite is on when he was on duty.
My lord. Gate number.
The duty was assigned where?
He was a porter posted at gate crossing 54A lordship.
What is that 54A?
That is crossing, railway crossing lordship. Where due to snake bite, he later succumbed lordship.
His husband is a porter.
My lord.
Porter post
traffic porter in railway lordship.
Who is appearing for railway?
Lordship, we are required to file counter in this case.
We will permit you, but have you not gone through the papers? Snake bite during the course of employment, he is entitled.
I need to check, Your Lordship.
Where is the scheme produced?
My lord.
Is it Annexure A7?
Annexure 5 and 5(1)A lordship. It starts from page 41 lordship. Page 41.
In Hindi?
No lordship. Coming lordship. It is in English lordship. Running page 41 lordship, annexure 5 lordship of
Page
my
41
lordship, 41.
Item number?
Annexure 5 lordship.
No, sir. There are. Then pagination is not telling. Page 41 is the last two paragraph of the scheme.
Perhaps
owning the payment of ex gratia lump sum
of my main petition, lords, not of OA lordships. I am referring CWJC, that is main petition before your lordship, page 41 lordship.
Where is the document to show that during the course of employment, the snake bite and all?
My lord, that is annexure 1 lordship.
Who has given the report?
My lord. the authorities of railways have given the report, Lord. Annexure 1 and Annexure 2, two documents that supports that the husband of the petitioner died during the work in harness due to a snake bite, Lordship. Your Lordship may have pleasure to see Annexure 1 at 32 page, Lordship.
What was the post held by him?
Traffic porter.
Porter.
Right.
Reason for death, real accident or otherwise. Answers otherwise died during duty.
They have mentioned during duty?
Yes.
All right, counsels for the respective respondents are hereby directed to file their counter affidavit positively by next date of hearing. Release this matter after 4 weeks. It is made clear that no further time would be granted.
Oblige, Lordship.
Year number 29, Union Affidavit versus Sonu Kumar for the petitioner is correct.
May please, Your Lordship. The order dated 22/10/21, my lord, by which the Learned Administrative Tribunal, OA filed by the respondent, has allowed, without considering the fact that he died in the year 2004, and so the circular dated 30/12/2019 is not applicable in the present case, my lord.
Compassionate appointment.
My lord. Actually, he is guided by the data dated 2/1/2092, my lord, which is Annexure 1, and he died in 2004. Thereafter, the revised circular has come in 30/12/2019, my lord.
30/12/2019,
the revised circular has come, and which is not applicable.
30/12/2019.
2019, my lord.
This is applicable as held by CAT.
It is applicable from the date which the circular has come. That I have.
Correct. Now CAT has held what?
It has been held to 192, my lord. To this, he has been guided by the circular.
CAT has held that the circular.
No, CAT held that it will be, from the respective dates this circular will become. He has held it's not so, but he has directed to the authority to consider the application of the petitioner within 4 months, my lord.
To notice to the respondent. Necessary requisite shall be paid within a period of 2 weeks. Release this matter after 8 weeks.
My lord, in the meantime, the stay should be granted.
Huh?
In the meantime, the stay should be.
Why stay? Who is appearing for respondent?
I will file wakalat.
For respondent. What is his name? Usha Devi.
Usha Devi died, my lord. Actually, Sonu Kumar, the son is here.
You are representing?
Yes, I will file wakalat within 1-2 days.
Right, counsel for the respondent, Mr. So and so. Pierce. To file counter affidavit. In the meanwhile, order of the CAT shall not be given effect till next date of hearing.
Next item, my lord. Just now I have received counter affidavit, my lord. So I
want to file counter?
I want to file reply, my lord. Just now, my lord, I have.
Filing reply to the counter affidavit. Release this matter after 4 weeks.
Supplementary affidavit.
Supplementary affidavit.
We have filed the supplementary affidavit pursuant to your lordship's last order, bringing on record the fact that there was no advertisement, your lordship, and you has to file that reply. A supplementary affidavit.
Filing counter statement to the supplementary affidavit.
Yes.
Supplementary affidavit number 1, 2, 3.
2, your lordship.
Still how many?
No, we don't have to file.
No.
We have given that effect, to that effect, we have given in memo of appeal itself that there was no advertisement. Your lordship has on the last occasion